believe that, this juror, even by responding back, which he shouldn't have done, causes an issue for the defense, at least for the integrity of the jury. My client and I are concerned about, this jury, can it be fair and impartial? So I, again, based on what's been discussed here, make a motion for mistrial.
Okay. Well, I'm going to deny your motion for mistrial. A couple of things. First of all, I agree that the juror shouldn't have replied. First of all, the juror also indicated that he's not really concerned about it. And I think, one of the main reasons that we enter orders that jurors are not to be videoed is so that there's, for juror security. So this individual apparently wasn't concerned with that information. Secondly, I'm not even certain that it happened. It's hard to drill into why he would get a video from, or a message from a friend in Indiana about being on this case, and if he wasn't, I can't explain it, but I'm satisfied that that the cameras over which I have control in this courtroom, that being the media cameras, aren't filming the jury. It's possible, I suppose, that someone in the audience used their phone to make that video. I don't have the results of the efforts by security to try to track that down. Hopefully I will get something. But I'm not satisfied that this juror has indicated in any way that this is going to make it more difficult for him to serve on this jury. He indicated he wasn't concerned. So I'm going to deny the motion for mistrial. I intend to just indicate, I intend, frankly, to do two things. I'm going to, again, read the jurors the instruction that I've been giving them regarding communication. I think it's important to reiterate that for them. I'm also going to advise them that I've made a specific order that they're not to be videoed, and that from my investigation as a result of this issue, that they haven't been videoed. As part of that, I think I'm going to need to relate to them that a concern has been raised, only because beyond that, they'll wonder, why are you telling us all of this? But that's what I intend to relate to them. Mr. Lezay, any objection to that? Mr. Freilich?
No, Your Honor, but I have a concern.
Okay.
So would the court consider striking that particular juror because we have alternates? The other thing I'm worried about is there going to be discussion about, well, why did the court want to talk to you, to this male juror? I have some concerns about that as well. So would the court, consider maybe striking this juror? We've got several alternates.
Sure. Well, first of all, regarding a conversation the jury might have about why did the court want to talk to you, that's why I indicated that I would tell them that a concern has been raised. And they'll get it, oh, it was the guy you brought out here. So, and I don't think the jury will in any way look on him disfavorably because he was simply reporting to the court something that occurred, which is what I want people to do. So that's that. But let me turn to the state. Mr. Freilich has asked that I strike that juror.
And I don't think there's a basis to do that at this time based on the nature of the voir dire with that juror.
I don't either. I frankly think this juror has perhaps skirted a little close to my rule. Instead of responding thank you or asking when it occurred, he should have said something along the lines of, thank you, but please don't talk to me on this until this trial is over. On the other hand, friends might feel that's a bit terse to reply, but I'm going to reinforce that. I think the point is that the reply that he made was so innocuous that I'm not satisfied he violated my order to the point where he would have to be excused. Again, I think the notion that nobody on this jury is going to get any text messages from anybody while this trial is pending is something I simply can't control. So I can't find that in any way would cause me to strike him. And again, he's indicated he wasn't concerned with being shown as a juror, so he hasn't formulated any sort of bias or prejudice as a result of that event. He's just simply reporting what happened, which is what I expect a juror to do. So I'm going to deny the motion. Your motion is noted, Mr. Freilich. I'm going to deny the motion to strike him, and that's what I intend to do.
Thank you.
Okay. Anything else, Mr. Lezay?
No, Your Honor.
Mr. Freilich?
No, Your Honor.
Okay, we'll bring the jury. Be seated. Welcome back, ladies and gentlemen of the jury. And I need to take up an issue with you before we get started. A concern has been raised by one of your number that perhaps at some point in time, perhaps yesterday, that the jury may have been videotaped and put out on a live stream. And a couple of things I want to advise you about that situation. First of all, I appreciate the fact that that it was reported right to the bailiff, and that's what I need you to do. As a result of the report, the matter has been looked into by scouring the videos that have been taken of this trial, and at no point in the videos that I have authorized to be taken have you been videoed. Just to give you a little more detail about that. In this trial, I've allowed 3 cameras to be utilized. Those cameras are situated in such a location that you're not being videoed by them. When I need to, I look at the media room and I can stop the video feed at any particular time for a particular witness. Perhaps you've seen me do that and heard me do that. I've entered an order that no one in the audience is allowed to use a cell phone to take photos or videos. At this time, security is scouring the videos of this entire trial to see if anybody in the audience has been doing that. I can tell you that I can see everything from up here and I haven't noticed it. And in case you wonder, this courtroom is also being monitored in various different locations. So we're being watched while we're being watched. Okay. The people that are videoing it are being watched by the people that are sitting in the security office downstairs. So I want to assure you that order was entered by me. I'm endeavoring to great lengths to make sure it's abided by. And as far as I know, right up until this very minute, my orders have been followed to a T. It doesn't mean I'll stop looking into it. And I would encourage any of you, if you have a concern about that, as we go forward, report it to the bailiff. There's one other thing I want to do because it's important. I'm going to again give you this instruction. You've heard it before and you'll hear it again. Do not communicate with anyone about this trial or your experience as a juror while you are serving on this jury. Do not use computer, cell phone, or other electronic device with communication capabilities to share any information about this case. For example, do not communicate by blog, email, text message, Twitter, or in any other way on or off the computer. Do not permit anyone to communicate with you about this case. And if anyone does so despite your telling them not to, you should report that to me. I appreciate that it is tempting when you go home in the evening to discuss this case with another member of your household, but you may not do so. This case must be decided by you, the jurors, based upon the evidence presented in the courtroom. People not serving on this jury have not heard the evidence, and it is improper for them to influence your deliberations and decisions in this case. After this trial is completed, you are free to communicate with anyone in any manner. That's all I'm going to have to say about that for right now. I believe the case is still with the state. Actually, we're at cross-examination, however. Detective, I think you were on the witness stand. I'll have you come back. And I will just remind you, Detective, you're still under oath.
Yep.
I'm also going to remind everyone to please use their microphone. As you can see, we've switched court reporters. We are now using the DAR system, which is an excellent electronic system, but I want to make sure everybody's using their microphones. Having said that, Mr. Freilich, you've gotten a few complaints, so try to tend to your microphone, but I'm probably the worst offender. So go ahead.
Thank you, Your Honor. Detective Groff, good afternoon.
Good afternoon.
So on February 23rd of 2022, were you called down to the police department?
Yes,
What time did you get there?
I probably arrived about 4:45 in the morning, I think.
Okay. Is that kind of a normal shift for you, sir?
No,
What's a normal shift?
7 a.m. to 3:30 p.m.
And why were you contacted to get down there at 4:45 a.m.?
As far as my duties as a detective, we can get called after hours for major crimes, and in this case, I was called by a supervisor to ask if I would assist in a homicide investigation.
And were you told that there was a minivan that was found parked at the Eastman Avenue apartment complex?
Initially, my initial phone call, no.
Okay. At some point, then you were told that there was a minivan that was of interest, correct?
Yes,
And that was parked over at the Eastman Avenue apartments.
yes,
You interviewed several people, correct?
yes,
One being Tara Pakinich, correct?
correct.
And did you also talk to Stephen Hendricks?
No,
Did you talk to Taylor Schabusiness as well?
yes,
You talked to Ms. Pakinich and Ms. Schabusiness on the same day, fair?
yes,
Did you talk to Ms. Pakinich first?
yes.
And was it such that they were down at the police department when you arrived?
No.
Okay. You got there first?
I don't recall if I got there first or if Miss Pakinich was there first, but Miss Schabusiness was not there when I first arrived.
Okay. So you took Tara Pakinich into a room, correct?
Yes,
And what did you talk about? The fact that she found something in a bucket in the basement of her house?
yes, of course.
And then you followed up with further questions with regards to that?
Yes, I did some preliminary questions, yes.
And did she indicate to you that Taylor Schabusiness and her son were friends?
Yes,
That they went to school together?
yes,
Went to high school together at Bayport?
yes,
And did she indicate to you that how she came upon the bucket in the basement?
Judge, I'm not concerned any of this is particularly prejudicial, but it is all hearsay. Ms. Pakinich testified, and he can and did ask these questions to Ms. Pakinich. The statement that the detective took from a witness who is not a party is hearsay information.
Well, it's really not offered for the truth of the matter, Your Honor. It's just to get some background information. But I can move on.
When you move on. So the question's withdrawn.
So after you finished talking to Tara Pakinich, then was Taylor Schabusiness brought in?
yes,
Okay. And initially you introduced yourself, correct?
yes,
And Detective Kemp was there. Is that fair?
That's correct.
Were you sort of the lead detective on this?
Well, initially I was one of many detectives who came in to do the initial investigation, but throughout the course of the investigation, it took a more of a lead role.
Okay. So in the interview room, you swabbed your hands, correct?
Yes,
Did you take any pictures?
I did not.
You offered her some water, correct?
At some point, yes.
And then you told her that a few hours ago, officers went to a residence on Stony Brook Lane and a bucket was found with a human head in it, correct?
Correct.
And what was her response? Do you remember?
Something to the fact of, oh, really, or something to that.
Did she say that it's pretty effed up?
Yes, that would be correct.
Pretty fucked up, correct? That's what she said.
Yes.
And did she indicate to you that Shad was her ex-boyfriend?
Eventually, yes.
And then did you confirm that she lived on Eastman Avenue,
Yes.
apartment 1 at 2353 Eastman Avenue, correct?
Correct.
And she indicated that she lived there with a Scott Tomes.
Correct.
And then you had further questions, correct?
Of course.
You asked her questions about things that may be in the basement. Is that fair?
Yes.
And did she give you comments like, well, that's a good question?
That sounds familiar. Yes.
Did she say that she blacked out at some point?
Yes.
And did she tell you that she needed time to think?
Yes.
And you said, that's not a problem. Take your time, correct?
That's correct.
When you were talking to her, was she smiling inappropriately?
I did not observe that. No.
Did you hear her laugh sometimes during the interview?
I believe so.
Her mood, did it kind of go up and down during your interview with her on March 23rd?
No.
Now, there were 2 detectives in the interview room with her, correct?
Correct.
And was there any sort of intimidation towards her at all?
Nothing.
During the time that you talked with her, did she say things that were sort of bizarre?
Well, some of the acts that she described that she did, were something that was not common, but bizarre. I wouldn't say bizarre.
Unusual? How about that?
Sure.
Okay. And you told her that this was kind of an ongoing investigation, and the detectives and the officers and the law enforcement personnel on the scene were trying to figure out what was going on. Is that fair?
Yes.
Because law enforcement really didn't know what was going on, correct?
Absolutely not.
It was, would you say it was a situation that was unfolding and developing?
Yes.
She did indicate to you that did she exhibit responses that were kind of short and snippy?
No.
Did she say that she did not know what was going on?
Well, she did make a comment that at one point she had blacked out. And again, I assured her that she could take her time, and she had plenty of time to remember what she did.
Now, you've been on the force you've been an officer for 27 years, correct? You've got a lot of experience. Is that fair?
37 years.
37 years. Oh, sorry.
I'm sorry, 30 years, and yes.
30 years. Okay. So, and you've been a detective for 17, yes?
Yes,
You've worked with people that have used meth, correct?
I have.
Meth is a very powerful drug, isn't it?
It can be, yes.
It can cause people to act and react in an unusual way. Is that fair?
Yes.
When you were talking to her, she had some problems answering questions, correct?
No,
She would mumble and trail off when you would ask her a question. Is that fair?
no.
She said a few times, "Damn, my head." Didn't she say that during the interview?
I don't know if she's referring to her head or Mr. Thyrion's head.
Okay. You didn't know what she was talking about, correct? On that topic?
I don't recall.
Did she tell you that she was coming off a high or a buzz?
No.
She did say that she was paranoid, correct?
She did mention the word paranoid in terms of why she had left the residence.
And she said it was really weird. She made that comment, correct?
I don't recall.
And she said, I think it was the dope. Didn't she say that to you?
She did make those comments, yes.
As far as the investigation was concerned, there were no human remains found at the Eastman Avenue apartment. Is that fair?
Correct. Not inside the apartment.
Correct. There was a minivan. Well, strike that. At the apartment, Scott Tomes lived there, correct?
Yes.
And he also owned a gold-colored Town and Country minivan, correct?
Correct.
When you were talking to Ms. Schabusiness, she did say something about she heard gunshots, correct?
Correct.
Did you hear any gunshots
When?
when you were either at Stony Brook or at Eastman Avenue?
I was never at Eastman, but when I was at Stony Brook very briefly, which was much later in the day, and I did not hear any gunshots.
You reviewed a lot of different reports and talked to a lot of different detectives, including Detective Scanlon, Detective Kemp, Lieutenant Buckman, a lot of the other officers involved, correct?
Yes.
Did any of the officers provide any details or reports about any gunshots being fired at either Stony Brook or Eastman Avenue on or about February 23rd of 2022?
I don't recall who said, but I do recall that during the time that officers were called to the Stony Brook residence, that there was another call that officers were on that might have involved gunshots.
At some other location though, correct?
I'm sorry?
At some other location, not Stony Brook or Eastman Avenue, correct?
Correct.
During the interview that you had with Taylor Schabusiness, did it go on for about 6 hours?
That's an estimate on my part. I'm not sure.
That's fair. That's fair. So you started in the morning, and then at some point you took a break because she had to go over to St. Vincent's Hospital.
Yes.
And then you came back and then resumed the interview, correct?
Yes.
All at the Green Bay Police Department?
Yes.
You had a chance to look at her hands, her thumbs, and her fingers, correct?
Yes.
She had some scratches and some deep cuts on her thumbs and fingers. Is that fair?
She had a cut on her thumb and some scratches. Yes.
And she got medical treatment for that?
Yes.
Were there, when you asked Ms. Schabusiness some questions, sometimes she was non-responsive. Is that fair?
No.
She did not answer your question every time you asked one. Is that fair?
I would not say that is correct.
She said some odd or weird things though, correct? During the interview? Specifically, well, the arm or something like that would rebuild into muscle.
But yes, she made several comments of, when she was strangling Mr. Thyrion that, his muscle would rebuild, and made several comments about, that she forgot to leave, or she forgot to leave the head behind in the bucket in the basement. Those types of comments in terms of describing her actions and what she was doing. But in terms of those being bizarre, I did not find that to be in any way, shape, or form.
You found it to be odd though, especially when she laughed about it, correct?
Well, I did not feel that way.
But she did laugh about it when you talked about it, correct?
I think there would, maybe at one point there was kind of a smirk or something, but it was in the context of just how she replied back to me.
And she did tell you that on some date before February 23rd of 2022 that her and Mr. Thyrion were smoking ice, correct?
Smoking, yes. Ice,
She-
or
she-
methamphetamine,
Yeah. She used the word bitch, correct?
initially.
And then it changed from ice to methamphetamine, yes?
Yes.
And then she indicated that a meth pipe and a plastic bindle would be in the basement.
She said that.
She told you that it was a weird night. Is that correct?
I'm sorry, can you repeat
Did
that?
she say that it was a weird night?
That's possible.
And then she did talk about drugs, and she talked about the fact that she's been off drugs and then she's on drugs. She said words to that effect. Is that right?
We did talk about her drug use in the days previous to the interview. I believe she did make comments of using drugs in the past. As term of her, how much, I don't recall that.
Okay. And fair to say that during the interview, oftentimes Ms. Schabusiness would say, I don't know. She didn't know the answer to your question.
I'm sure that she probably had some of those answers.
She would say, I have no idea, correct?
I guess I would have to know specifically what I was asking her.
And is it fair to say that some of the things that she said just didn't make sense?
No,
You sort of had a narrative and she kind of went along with it, correct?
I would not say that, no. I did repeat several of things that she would say to clarify, but I would not say that I led her in any way.
When you were talking to her, oftentimes she'd have her hand over her mouth, correct?
It's possible.
And she would talk very softly, correct?
I was able to hear her.
But she did talk softly, correct?
I don't know.
She said something about that she was tweaking out, or that she was tweaking. Do you know what she meant by that?
I do not recall those specific words. I would know what she would mean by tweaking out, though, yes. And I don't recall as to what time period she was talking about either.
Okay. Is it fair to say that the first part of your interview was about 3 hours, and then you went to the hospital?
That's fair.
You came back, and then the second part, was that about 3 hours, or how long was it?
I'm not sure.
Not sure. A couple hours, though?
Sure.
Took a while to ask questions and try to figure out what was going on. Fair?
Right. As I was interviewing her, there are investigators who were at the house. And so it was an ongoing and continuing investigation to determine what happened.
Right. During the interview that you had with her, she said, I didn't mean for all this to happen. I'm sorry. Is that fair?
I think that she did make a comment as to initially that she did not mean to kill Mr. Schabusiness. I'm sorry, Mr. Thyrion.
You had cases involving asphyxiation, correct?
Yes.
And can you tell me what we mean by that? Is it choking?
Asphyxiation.
Yes.
Choking is another word. Is when someone's windpipe or has been blocked and breathing has been obstructed.
Is it a situation where people that maybe are into this kind of thing choke each other to get some euphoria or pleasure out of it?
I have heard of that practice.
With regards to this case, law enforcement did find 2 dog collars or 2 chains. Is that fair?
Yes.
During the interview, Miss Schabusiness said something about, I can't think right now. Remember that?
No.
She said, I'm fucking nuts. Remember that?
No.
Were you surprised by some of the things that she said to you?
Overall, in the context of what we were discussing and the information that had been provided to me?
Yes. And did she tell you that the body can rebuild itself?
She made that comment, yes.
There was a second interview on February 28th of 2022 back at the Green Bay Police Department, correct?
Yes,
And Detective Scanlon was there for that.
he was.
Did he kind of ask most of the questions for that interview?
I think it was 50-50 in both our parts.
And did Ms. Schabusiness indicate to you or to Detective Scanlon that she was freaking out?
I do not recall those exact words. It's possible.
Do you recall, though, that she talked about having a lot of issues with open areas? Remember that?
But she was talking specifically about the basement area that she was in.
She didn't like the open area, though, correct?
No.
I'm correct on that?
I'm sorry?
I'm correct that she did not like the open area. Is that right?
She did not like the open area of the basement at Stony Brook
Okay.
in Green Bay.
Thanks. That clears that up for me. Her emotions came out during the interview. Is that correct?
It's possible.
Did she tell you that she got very angry at herself?
Once again, it was quite a lengthy interview. I do not recall every single comment that she made.
Okay. She did say during the interview that there were some times where she nodded out, correct?
Yes, I do recall that.
And she indicated to you that her and Shad went in the basement and within about 5 minutes got to it, correct?
Got to it.
Yes.
She stated that Chad produced a couple chains. Yes.
Yeah. Within 5 minutes of being down there, correct?
Correct.
And she told you there was no kissing, correct?
I do not remember that at all.
And she told you there was no sex, correct?
She said that it was starting to lead that way, but there was no sex while Shad was alive.
There was no penis to vagina sexual intercourse going on, correct? Is that fair?
Penis to vagina, no.
I'm correct about that, right?
She never stated that that occurred.
Okay. And did she indicate that her and Shad Thyrion had took a toke off of some meth at the Eastman Avenue apartment in the bedroom?
Yes.
Okay, I have nothing further.
Are you correct?
Very briefly, you were asked about a couple of terms, nodding out and tweaking. Are those terms that you have encountered in your experience as a detective or as a narcotics investigator?
Yes.
What do those terms mean to you, starting with nodding out?
Nodding out is a term typically heroin users would describe when they would become drowsy
As a result of the drug use?
as a result of the drug use.
And how about tweaking?
Tweaking, it can refer to methamphetamine users. It's a stimulant, so it could cause them to be hyper or sudden body movements, and that is a result of the use of methamphetamine.
No further questions.
Anything on that, Mr. Frick?
No.
Okay, thank you. You can step down. Does the state have any other witnesses?
No, Your Honor. At this time, the state rests.
Okay. Ladies and gentlemen, the state has now rested their case. We're going to take a brief recess, and we'll reconvene in about 10 minutes. All rise for the jury. All right, be seated. The state has rested, then Mr. Freilich, the case would then turn to the defense. Do you intend to call witnesses, or do you want to address me on the stipulated facts?
Yes, before I do that, Your Honor, I'd like to make a motion for a directed verdict. Ask that the court consider.
Use the microphone.
Ask that the court consider that as it relates to the first degree intentional homicide count, I would argue that there is insufficient evidence to support that particular charge. There's insufficient evidence to show that my client, Taylor Denise Schabusiness, had any intent to kill ST Shad Thyrion. What we have here is some testimony from a number of law enforcement officers. We also have some video footage from an interview between my client and Detective Groff and Detective Kempf. It's clear that my client likely did consume and ingest methamphetamine with Mr. Thyrion prior to his death. My client provided commentary and answered questions from Detective Groff. I would submit that what she indicated that was that she had no intent to kill. The question is, did my client do it or not? That's another question. There are a lot of different issues here going on, but based on what she said to the detective, I'd ask that the court consider dismissal of the first degree intentional homicide charge on the grounds that there was no intent to kill. Also, there are really no eyewitnesses to whatever went on in the basement at 829 Stony Brook Lane in Green Bay. When Tara Pakinich and Stephen Hendricks went downstairs, they didn't find anybody down there. They found body parts, unfortunately, but they did not find my client there. My client was at 2353 Eastman Avenue, and that's where she was arrested. And there were no body parts over there. There were body parts in a van that was owned by Scott Tomes. That's not my client's minivan. That gold Town and Country Chrysler minivan belonged to Mr. Tomes. So there are a lot of issues here. As to the third-degree sexual assault charge, the state's got to prove that my client had sexual intercourse with Shad Thyrion. I believe based on this record, in the video, there's no evidence to show that my client had any kind of penis to vagina contact with Mr. Thyrion. We have testimony from the DNA expert that indicated it was uninformative as to the dildo. And I know that my client claimed that the dildo was used on Mr. Thyrion, but there's no DNA evidence on that. And so I would ask that the court consider dismissal of the third-degree sexual assault charge as well for those reasons. Thank you. Finally, as to the mutilating a corpse, count 2, again, there are no eyewitnesses to observe what really happened in the basement on the dating question. So for all these reasons, I'd ask that the court consider the motion for a directed verdict and dismiss these charges.
Mr. Saunders.
A reasonable juror viewing the evidence in the light most favorable to the state could convict. The state's met its burden. His motion should be denied.
Okay, well, these motions are fairly common in cases like this, and the court does have to, in these circumstances, look at the evidence in the light most favorable to the non-moving party. This is by no way the court making a decision about what the ultimate verdict in the case will be. That's up to the jury, not up to me. But the court's task at this point is to take a look at the four corners of the record, the evidence, to see whether the state has satisfied their burden of proof, at least to this point, such that the matter can move forward and be given to a jury. Each of these counts has 2 elements. The homicide count has 2 elements. The mutilating a corpse count has 2 elements, and the third-degree sexual assault count also has 2 elements. And the court is satisfied when considering the entire record in this case that a reasonable jury could conclude that the state has met its burden and convict based upon the evidence that has been offered thus far. Again, I'm to look at the evidence in the light most favorable to the non-moving party. That isn't necessarily how a jury will look at it in their deliberations, but that's what I'm to do at this particular point. And in doing so, I'm satisfied that these motions for directed verdict should be denied, and that's what the court does at this time. So those motions are denied. And so I'm going to turn back to you, Mr. Freilich. My understanding is as a result of Mr. Tomes not being here due to some health issues, that there's been a set of stipulated facts.
Yes, Your Honor. But before I do that, I know that my investigator had made attempts to contact Scott Tomes as part of the defense investigation in this case, and my investigator was not successful in making contact. But we did get a subpoena out, and the Brown County Sheriff's Department, I believe, subpoenaed Scott Tomes for court as a defense witness. The prosecutors did inform me promptly that he is not going to be available. Maybe he's got health problems or hospitalized, but they told me that he is not available. I've advised my client of this. I find that, and I'm not blaming the state, but I'm blaming him, that the timing of this seems suspect to me, that he's not available. I haven't seen any report, doctor's note, anything like that. So before I answer the court's question, I'd ask that the court consider a motion for mistrial because this witness is not here, has been properly subpoenaed, and I really have no recourse to call him and question him about the issues in this case. So I'd ask that you consider that motion.
Well, before I turn to the state and ask for their response, Mr. Freilich, what can you tell me? What was your expectation of what he was going to testify to?
Well, I have some highlighted sections from his statement that the state and I agreed on as to what his testimony would be about. But, when you call a witness, there may be other things that come up. But I'm working off a statement. I've highlighted the yellow parts that would be told to the jury if the court felt that was appropriate. But I felt the need, because I'm at this kind of crossroads with this kind of problem, that I would make this motion first.
Sure. But I don't think you have my question, because the question is, you've asked for a mistrial based upon the unavailability of this witness. So the question is, what was he going to testify to, so that I can assess the gravity of his not being here?
I understand. Okay. Thank you. I believe that he would testify that on that Monday night, I believe that would have been February 21st of 2022, that that Mr. Thyrion and Ms. Schabusiness came over, that he did not know Shad's last name, but he saw him before, and that he believed that they hooked up to get some meth or do meth. That would have been about 9 p.m. on Monday night, and that he had this gold Chrysler Town and Country minivan, and his keys were on a lanyard which hangs on a hook by his front door, and that he indicated that Taylor Schabusiness has used his vehicle in the past, but with his permission, and that she's always asked to use it. And then he said she did not ask to use the vehicle last night, and that he did not give her permission to take the vehicle. And he said he did not call the police to report the vehicle missing. And then he indicated that he was drinking some whiskey and cranberry juice, and that he sometimes gets drunk, but not inebriated. He indicated around midnight, Ms. Schabusiness returned home with his vehicle, and she went basically directly to her bedroom, that he had a suspicion she may be high on drugs, and that he believed the police arrived 15 or 20 minutes after Ms. Schabusiness got home. And then he talked about the living arrangements in the apartment, and that Ms. Schabusiness stays in the bedroom and he sleeps in his chair in the living room. So.
Okay. So the first thing I want to take up is Mr. Freilich's motion for a mistrial based upon the unavailability of Mr. Tomes.
So I think the motion should be denied. Essentially, everything counsel stated, the state is willing and has prepared a stipulation to that effect. So obviously I don't think that the drastic remedy of a mistrial is necessary. I do want to be quite clear. The state does not control Mr. Tomes. We in no way told him to disregard a defense subpoena as part of our case. We chose not to call him. We were advised about the medical issue, and we passed that information along to defense counsel. So I don't want it to there to be this record that we are influencing his unavailability in any way. Obviously, counsel can still attempt to have him here and still attempt to produce him. It's an issue the state deals with fairly regularly in trials. That isn't being done, so I don't think the defense failing to produce a defense witness is grounds for a mistrial, particularly when the state's willing to stipulate to everything the defense seeks to elicit, essentially.
Your Honor, I want to let the court know that Mr. Saunders promptly let me know of this situation as soon as he found out about it, so that was appreciated.
Okay. I don't want all the details, but as far as a medical issue, I mean, if you have a bad cold, that's a medical issue. If you are in the hospital for serious surgery, that's a medical issue too. Is he incapacitated? Is he just staying at home because he doesn't feel like getting out? Do we have a sense of that?
I think the latter. The information we received is that he was in hospital and would be for several weeks. That was the information we received from a relative.
Okay. Okay. Well, so in front of me then is a motion for a mistrial. A number of things. First of all, when I listened to the recitation of the information that Mr. Tomes was going to testify to, first of all, I'm satisfied that a lot of that information has already been testified to by other witnesses, particularly the individual, the mutual friend of Mr. Thyrion's and Ms. Schabusiness's, who was here yesterday, testified to some of the events that occurred at Mr. Tomes' apartment. frankly, some of the other information that Mr. Tomes was going to be testifying to that was referenced by Mr. Freilich, I think was brought in through some other of the witnesses. The information about the, what Ms. Schabusiness did with Mr. Thyrion while they were at Mr. Tomes' apartment. There was reference to potentially utilizing controlled substances there, that perhaps Mr. Tomes was in either a different part of the house or had his gaze focused somewhere else while they utilized controlled substances behind his back so he didn't see. That kind of information has come in other areas. Really, the only piece of information that I heard that doesn't sound like it came in any other fashion, except by indirect statements from Ms. Schabusiness in her interview with law enforcement, was the comment that, when she used his van in the past, she asked permission, and that she didn't ask for permission that night to use his van. And there's a couple of things about that particular piece of information. I remember the information in the video where the detective was asking her questions, and she indicated in response to her question, I don't know if he knew that I was leaving or not. I don't know. I think she was uncertain whether Mr. Tomes actually knew that she was leaving. And the reality of it is, if she was utilizing his van and she was uncertain whether or not she even knew about it, whether or not he even knew about it, then that might confirm a statement whereby Mr. Tomes says, yeah, she usually asked for permission, but that night she didn't. That would be very consistent with what she reported in her interview. Beyond that, I'm not really sure the extent to which that piece of information is so relevant, that his presence is needed here, as opposed to stipulating to the facts that are outlined. For all those reasons, I'm satisfied that the fact that he hasn't responded and arrived here today due to medical reasons, I'm not going to grant a mistrial for that reason. I am then going to turn to the parties to determine if there's anything else that needs to be recited regarding that stipulated set of facts, or whether, Mr. Freilich, you've actually gone through and recited it there. Is that what you would intend to have recited?
Mr. Saunders has it, Your Honor. So I'm just going to take another look at it real quick. And what I did was highlighted in yellow the relevant sections from the statement he gave to police, and then Mr. Saunders' office had it typed out. So it's in proper order.
Okay. Gentlemen, how do you want that submitted into the record?
I can mark it, and then perhaps the court can just read it at some point during the defense case.
You want the court to read it?
Yes, please.
Okay. Sure. Well, then we'll mark it as exhibit 111.
Thank you.
Okay. All right. So then, just for my own edification, Mr. Freilich, I would intend to read this to the jury as soon as they're brought back in.
Okay.
Other than potentially your client testifying, do you have any other witnesses that because then we're going to move right into other witnesses. But if you said, well, that's the only one, and then the only issue is whether your client's going to testify, then how we'll proceed is I'll bring in the jury, I'll read in these stipulated facts, I'll excuse the jury again, and then I'll have the colloquy with your client about her testimony. So can you give me a sense, do you have other witnesses?
Your Honor, I've looked at my list here. A lot of the witnesses I was going to call have already been called, so I think we're good. I will need some additional time to confer with my client on whether she wishes to testify or not, but
Okay.
that's where we're at.
All right, well then,
Just,
Mr. Saunders.
can I just quick, I know some of the defense, some of the law enforcement officers had defense subpoenas. Is it okay to cancel them then?
Yes, it is.
Thank you.
Okay, it sounds like all the other subpoenas that are out there are now canceled. Okay.
Thank you.
Anything else before bringing in the jury, Mr. Saunders?
No.
Mr. Freilich?
No.
Okay, so I'll bring in the jury, folks. I'll read them this stipulated facts. I'm going to excuse them again. We'll break for a little more so you can speak with your client about testifying, and then we'll come back and I'll have that colloquy with her and go from there, okay?
Okay, thank you very much.
Be seated. Ladies and gentlemen of the jury, the state of Wisconsin, the attorney for the defendant, and the defendant have stipulated or agreed that if Scott Tomes had been called as a witness, he would have testified as follows. Scott Tomes was interviewed by a Green Bay Police Department detective on February 23rd, 2022, and stated that on Monday night, the defendant had a friend over named Shad. Mr. Tomes did not know Shad's last name, but had seen him before. Mr. Tomes indicated he believed that he had his car keys on a lanyard which hangs on a hook next to the front door. Tomes stated his vehicle is a gold Chrysler Town & Country with Wisconsin tag 580ZJZ. Mr. Tomes stated Taylor has used his vehicle in the past, but with his permission, and that she always asked him to use it. She stated Ms. Schabusiness did not ask him to use his car last night and that he did not give her permission to take his vehicle. He did not report the vehicle missing. Mr. Tomes stated he was drinking last night and indicated he gets drunk but not inebriated. He indicated that around midnight, Taylor returned home with his vehicle. He stated she basically went directly into her bedroom. Mr. Tomes suspected Taylor was high on drugs. Mr. Tomes believed the police arrived 15 to 20 minutes after Taylor got home. Mr. Tomes was also asked about the living arrangements in his apartment and stated that Taylor stays in the bedroom and he sleeps in his chair in the living room. Mr. Tomes was later interviewed by a Green Bay Police Department detective on March 9, 2022. Mr. Tomes stated that A.J. Gannon and Taylor Schabusiness were at the Eastman Avenue apartment on Monday, February 21, 2022, before they left and came back with Shad Thyrion. Mr. Tomes stated that Gannon did leave on his own, leaving Taylor and Shad still at the residence. You will consider that testimony in the same manner as if it had been given under oath here in court. I have marked that as Exhibit 111, and that's being offered, Mr. Freilich.
Yes, it is, Your Honor.
Exhibit 111 will be received.
Your Honor, could that be published to the jury?
Um,
Probably not necessary, I
yeah,
guess.
I'm
I'll
not going to
withdraw that.
publish it to the jury because that would involve either putting it up on the screen or passing it through there. And I'm not going to have them read it, but it is Exhibit 111.
Thank you.
And then, ladies and gentlemen, I'm going to excuse you briefly again, so I'll rise for the jury. seated. Well, Mr. Freilich, my understanding is you'd like to speak with your client for a little bit about her decision as to whether or not to testify. Is that correct?
That's correct, whether she's going to testify or not testify.
My understanding is you can do that right back there to the side door. So we'll be in recess then. I'm going to be checking in on you, Mr. Freilich, by 25 after. But if you need a little more time than that, you need to let us know. But I'm going to check in with you about that time, okay?
Okay, can you just give me till 2:30, Your Honor?
Sure.
Okay.
2:30.
All
All
right,
right,
thank
we're
you.
in recess.
Okay, well, I'm a little surprised that the state's case came to a conclusion so abruptly, but I guess I shouldn't be. I called the court clerk in Green Bay yesterday, and she said that the trial was expected to conclude Friday. So, we're midway through the middle of the week, so I guess it's time to change sides. Okay, while we have this commercial break, let's look at this news story here. Let me get the photo. Oops. Oh, I just got a text. Just a sec. Okay, here we go. This is the photo that goes with this news story. And it says, morbidly obese bandits easily caught by bystanders. They make very slow getaway with trunk full of shoes. And this is says a group of three robust Sacramento shoplifters were caught on camera by a local witness who calmly walked up to the scene of the crime. The suspects were unloading multiple shopping carts, mostly filled with shoes, into the trunk of their car. The trio were allegedly stealing from a Burlington store in California, when a nearby man caught the getaway on video as it slowly happened. According to the Daily Mail, the Burlington department store location on North Freeway Boulevard in Sacramento was the target of the heist, which happened during the daytime with alarms blaring. Damn, look at those people stealing. Say hi to the camera, an amateur videographer said on video. Look at this, the man added before the remark that the group were also parked in a handicap spot. What is your name, ma'am? The bystander asked one of the women while filming the getaway car's license plate. The women then backed their red Dodge Charger through the discarded shopping carts before fleeing the parking lot. The Daily Mail spoke to the Sacramento police, who told told the outlet that they are aware of the incident. They added that the police or the officers responded, a police report was generated, and it is an active investigation. Burlington also provided a comment saying that the company is aware of the incident. A spokesperson reportedly said this is an ongoing investigation and we are partnering with local authorities. Burlington has approximately 1,000 locations in the United States and Puerto Rico. And okay, here let's oops, that's not going to work. Oh,
damn, look at these people stealing. Say hi to the camera. Look at this. What the? This?
hey, what's going on with her leg? She,
Handicap parking. License plate down. What's your name, ma'am? What's your name?
yeah, try explaining that to the jury. Okay. Let's see. Okay. So that was amusing. Okay, let's see. Oh, thank heaven they weren't wearing Daisy Dukes. I think that we would all need emotional counseling if that were the case. Let's see. I remember seeing some short videos earlier. We've got less than 5 minutes, so let's see. Nope, let's take a look. I can spot it. Nope, I don't see it in my history. Let me take a look and see what is new on YouTube. The hearing for Lori Daybell on whether her aunt can speak at sentencing was 46 minutes. Nate Eaton hasn't posted the outcome of the hearing yet. Yep. Hey, Owen is weighing in while I am looking at the YouTube feed to see if there's anything that is really brief. Oh, well, maybe if we have another break. Here's one that says whistleblower says YouTube US recovered non-human biological material UFO hearing. Let's earmark that. That's going to be too long for this break, or at least what remains of it. Let's see, there's been talk about Meghan Markle landing some mega deal so that she can become the next Oprah Winfrey. I think that is delusion and not anything to do with reality. She's got the what do they call it, the Sabine touch, where everything instead of turning to gold, it falls to pieces, and I don't see her becoming a movie producer and with major movie stars and then producing duds and having their careers go down with hers. So, I'm sorry, I don't buy it. Oh, here's another one for a longer break. Let's see. Says LA State Trooper finds body in trunk. That sounds like it's something that we need to watch.
Your Honor, I've had an extended time period. I appreciate it to talk to my client. We've talked about this prior to trial, but we talked again about it today. I've advised her that she has an absolute right to testify if she wishes, and she also has a right to not testify if she so chooses. I've given her advice. I've conferred with her. We've talked about this particular issue. It's her decision not to testify and exercise her right to remain silent.
Okay. Then I'll engage her in a colloquy about that in just a minute. But Mr. Freilich, then would it be my understanding that that you have no more witnesses, what you indicated before, and that when the jury comes back in, you'll be resting?
That's correct.
Okay. Then, Mr. Business, I need to address you personally. So your attorney told me that he just spoke with you about some of your constitutional rights that are coming up right now. And those rights are that you have an absolute right to testify and you have an absolute right not to testify. Do you understand that?
Yes.
Okay. Mr. Freilich, the microphone. not
Oh,
yours,
sorry.
hers.
Sorry about that.
So, Mr. Business, those rights belong to you. They don't belong to Mr. Freilich. They don't belong to the state. They don't belong to me. Those rights belong to you and you alone. Do you understand that?
Yes.
Okay. And my understanding from listening to Mr. Freilich is that you've decided that you would like to exercise your right not to testify. Is that correct?
That is.
Okay. Now, I know you've spoken with your attorney. Do you feel you need any more time to talk to your attorney about that decision?
No, I did not.
Has anybody made any threats or promises to you to get you to make that decision here today?
No.
Okay. Any further inquiry you'd like me to make, Mr. Lizet or Mr. Saunders?
No.
Mr. Freilich, any further inquiry you'd like me to make of your client regarding that decision?
Just inquire if there's been any pressure on her.
Okay. Mr. Business, has anybody placed any kind of pressure on you to make that decision?
No.
Okay. All right. Well, I'm satisfied based upon the conversation that I've had here with Mr. Business that number one, she understands her rights. She has both of the rights to testify and to not testify. The issue, of course, being you can't exercise both of those rights at the same time. You can only choose one. She's choosing the right not to testify here today. I'm satisfied that she's done that after consulting with her attorney. They took a little bit of extra time. I gave them better than 10 minutes to speak about that. That was the amount of time that Mr. Freilich wanted, and they were back here when I came into court. So they've had an opportunity to discuss that. Ms. Schabusiness has indicated to me she doesn't need any more time to speak with her attorney about that decision. I'm satisfied that her decision is freely, voluntarily, and intelligently made here today. Of course, when it comes time to address the jury instructions, Mr. Freilich will have to address, I think it's instruction 315. I think that's the instruction about that I could give to the jury potentially about, and I'm not sure if it's in your packet, but we'll certainly take it up. It's an instruction about instructing the jury that they're not to hold her decision not to testify against her, and that's another choice that she will have to make. If it's not in the packet, I'll get it for you, Mr. Freilich, but I'm sure you've done enough trials, you're aware of that instruction, and I'll make sure it's available to you, and we'll have that conversation later, okay?
Yes, Your Honor. Thank you.
Very good. I'm satisfied, therefore, that Mr. Business is choosing not to testify. Then what we do is we'll bring the jury back in. I'll ask Mr. Freilich if he has any other witnesses. Mr. Freilich, based upon the representations he's made, is going to indicate that he's going to rest. And then we have a choice really to make as to how far we want to go today with the jury sitting here. Either try to press forward or to release the jury and work on the jury instructions and start tomorrow with instructions and closing arguments. Does the state have a preference as to either of those, Mr. Saunders?
Our preference would be to proceed today.
Any objection to that, Mr. Freilich?
My preference would be to go with the jury instructions today and proceed tomorrow with opening or with closing statements.
Okay. Well, I can tell you that I don't have to make that decision right at this minute. I'm going to bring the jury in. We're going to finish up the case and we'll go from there. And then I'll let you know what I've decided as far as that goes. All rise for the jury. Right, be seated. Okay. Ladies and gentlemen, the case is still with the defense, so I'm going to turn to Mr. Freilich. Mr. Freilich, do you have any other witnesses you wish to call?
Your Honor, no other witnesses. Defense rests.
Ladies and gentlemen of the jury, the defense has rested, so the evidentiary portion of this portion of the trial is now concluded. Just to give you a little bit of a roadmap as to what occurs now, The attorneys and I need to work a little bit on finalizing the instructions that I need to give you regarding the law. Then the attorneys would do closing arguments, and then you would go into deliberations. What I'm going to do is I'm going to excuse you again, and I'm going to start working on these jury instructions with the attorneys. I'm not thinking it's going to take us too long, but probably longer than the other breaks you've had. But that's what's going on. Progress is being made. And I'm hoping that within a half hour, maybe slightly more than that, you'll have a better sense of the timing for the rest of today. If I run into problems, perhaps I would dismiss you for today. But at this point, I'm thinking that I'm going to have you wait, and we'll get into instructions and closing arguments today. So that's a bit of a roadmap going forward. But with that, I'm going to excuse you again. All rise for the jury.
Okay, well, that is a surprise. Okay. Jury instructions are usually pretty dry.
Whether to move forward today or break, send the jury home early, and then come back tomorrow. I'm always keeping in mind just the timing that we gave them overall, that this trial would take about a week. I'm concerned, I don't know the duration of the next phase of this trial. I'm concerned that if we come back and finish this piece tomorrow, I don't know how long deliberations will go on the first phase, and then we have the second phase. So I'm not inclined to stop at this point. I'm inclined to push forward. And having said that, then, I think my judicial assistant should have put on your tables copies of the proposed jury instructions and verdict forms. Mr. Saunders, did you get a copy of those?
I did.
Mr. Freilich?
Yes.
Okay. Then what I'd like to do is just go through with you those instructions. There are going to need to be some modifications, which my judicial assistant and I will work on when we break. But starting out with, I would propose giving jury instruction 100. I will note that I'm going to jump way to the end after starting at the beginning, that instruction 602 is instruction after evidence has been received on issue of guilt, where a plea of not guilty has been joined with a plea of not guilty by reason of mental disease or defect. It's suggested that this portion, or that this piece, this instruction, be inserted to instruction 100 or given following the instruction on the offense charged. My inclination is to put it right at the end of 100 because in my mind, that's where it makes most sense. Any objection to that, Mr. Saunders?
No.
Mr. Freilich?
No.
Okay. Then I would intend on giving 103 evidence to find. Then I would intend on giving also 115, one defendant, 3 counts. There's a couple of modifications that need to be made here. First of all, on the version that you have, I've used the initials SRT for Mr. Thyrion. And I think we already talked about that way back when we were picking the jury, that we were just going to insert Shad Thyrion, and that's what I would propose to do. In fact, I've already told my judicial assistant to make that change. Any objection to that, Mr. Saunders?
No.
Mr. Freilich?
No, Your Honor.
All right. The other thing that I'm not sure if it was corrected on your version, I think it was, and I'll raise this issue. The criminal complaint had the date here as February 22nd, whereas the information had February 23rd. The first draft that I looked at that I had my judicial assistant work on had February 22nd. We changed it to the 23rd. I just want to make sure, I think in your copy that you have, it should say the 23rd. I just want to make sure that that's the date we're looking at.
Mine
That's the
says February
information.
22nd.
Yeah,
It says the 22nd?
Yes.
Okay,
Yeah.
so here's what happened. I made the changes in the version that she gave me. She didn't correct it in the version she gave you. But I'm aware of that issue. It's not something like, my God, I'm not expecting that we're getting all these typos. I knew about that issue. That's why I'm raising it. I fixed it in every other time I've read it to the jury. I had it as the 23rd because that's what the information says. The first time that these proposed instructions were drafted for me to start reviewing was before we even selected a jury. I was working on these, and it said the 22nd. So I had her change it, but clearly that didn't happen in your version. It should be the 23rd, Mr. Saunders, am I correct?
No, it should be the 22nd.
Okay.
Tuesday, the 22nd. The draft we have says Wednesday, the 22nd. I think the information's right. The criminal complaint was in error, and that's the state filed an amended criminal complaint fixing that date. In any event, I think based on the testimony, it should be February 22nd.
And so now I'm wondering if I was mistaken, because I recall at the time I was preparing my initial instructions to give to the jury, I asked my judicial assistant to check with the information and make sure that the date that I instructed comported with that. So now I'm thinking she changed your versions, and I'm looking at the old version because mine says the 23rd, but yours actually has the right date. So I think the 22nd, because that is that's in the information. That's the instruction that I gave to the jury at the beginning. So we'll use the 22nd. Any objection to that, Mr. Freilich? That's what the information says.
Your Honor, just from my perspective, I'm looking at a criminal complaint that was filed on March 1st of 2022, and the charging date is Wednesday, February 23rd of 2022. You know, it's confusing. It's complicated because we don't know the exact date when this may or may not have occurred. Was it February 22nd, February 23rd? I don't know.
Sure. There's a couple of things I'd respond to that, Mr. Freilich. First thing I'd respond to that is the information is the charging document, not the criminal complaint. That's the first thing I'd say. The other thing I'd say is instruction 255, which has been proposed to me, is the instruction stating state need not prove exact date of commission. We'll get to that in a minute, but I'm satisfied that the charging document is the one we need to follow because that's the official charging document as opposed to the criminal complaint. So I don't know what was heard at the preliminary hearing in this case or what the waiver was to, but that's what the charging document says.
Your Honor, just to, the court probably already knows this. I just want to make a record. The criminal complaint does have February 23rd of 2022 as the charging date, filed on March 1st of 2022, Brown County, Wisconsin. And then the information, which is the charging document, that has a different date, February 22nd of 2022, and that was filed June 2nd of 2022. For me, it's a little bit different because I wasn't the lawyer at that time. It was Attorney Jolly, but I'm just noting that all for the record.
What, and to what end? Are you asking me for something?
Well,
I mean, if the state thought it was on the 23rd and then they changed it to the 22nd, would appear to me that it's not clear what date this allegedly happened.
Okay. Well, what I'm indicating to you is that the charging document is the one that's going to be accurately reflected in the instructions. And I'm also noting 255, which we'll get to in a minute, addresses this very issue. So I'm going to change. I'm not sure if that's an official objection, Mr. Freilich, and I'm not sure what you're suggesting, but the instruction 115 is going to have Tuesday, February 22nd, 2022 in the city of Green Bay, Brown County, Wisconsin. And then where it indicates SRT, it's going to say Shad Thyrion. So 115 contains 110, first degree intentional homicide. It contains 1193, mutilating a corpse. And in that particular instruction, we need to look at the element piece. And it would seem to me that the word that has been utilized in this case is dismembered, but we have to make a alternative selection. Mr. Saunders?
Yeah, I have no objection to that.
Okay,
Dismembered.
Mr. Freilich, dismembered?
Are you asking whether to use mutilated, disfigured, or dismembered?
Yes.
Can I have a minute to confer with my client? Yes, we would agree with dismembered.
Okay.
That, Your Honor, that last comment was an objection, just to let you know.
Then the other selection we need to make there is in the very next sentence. This requires that the defendant acted with the purpose to conceal a crime or avoid apprehension, prosecution, or conviction of a crime. So, Mr. Saunders, does the state have a specific request?
I think conceal a crime fits the facts best. So
Mr. Freilich?
Agreed.
Okay. Conceal a crime will be the alternative we'll select in instruction 1193. Then we move on to count 3. That's instruction 1218A, third degree sexual assault, sexual intercourse without consent. Again, the changes from SRT to Shad Thyrion will be made, although there aren't any other alternative selections that need to be made. So that instruction will be changed. You'll get a chance to review the final version, and then that's the one that I would give. Moving on, I would propose to give instruction 140, burden of proof and presumption of innocence. 145, information, not evidence. 147, improper questions. 148, objections of counsel, evidence received over objection. 150, stricken testimony. There was very little stricken testimony, but I think on only one occasion did I strike any testimony, but I'm going to give 150 because I think it's appropriate. 155, exhibits I will give. 157, remarks of counsel I'll give. There's 158. I've already given that at various times, so I will not give that again. That's recording played to a jury that's supposed to be done at the time, and we did that, so I won't give it again. 160, closing arguments of counsel. I will give that one. Next one is 170, circumstantial evidence, and then what I direct the attorney's attention to is the bold or the capitalized instruction indicating that if evidence of flight, escape, or concealment has been admitted, see instruction 172. That's included here. I would propose to give both instruction 170 and 172. Any objection to that, Mr. Saunders?
no.
Mr. Freilich?
Oh, Your Honor.
Okay. On 172, we need to make some selections. The first line, evidence has been presented relating to the defendant's conduct after the alleged crime was committed or after the defendant was accused of the crime. I think the first option is the appropriate one. Mr. Saunders?
I agree.
Mr. Freilich?
I agree.
All right. Option 1 will be selected. Okay, moving on. 180. There needs to be some work on that. I intend to give 180. The capitalized portion of the instruction indicates, add the following if a statement resulting from an unrecorded custodial interrogation is admitted at trial for a felony and no exception applies. I don't think that applies in this case because although there was custodial interrogation that was offered, it wasn't unrecorded. In fact, it was entirely recorded. So I think I take that paragraph out, but then continue on with the bottom paragraph. Any objection to that, Mr. Saunders?
No.
Mr. Freilich?
Taking off that bottom paragraph where it says continue with the following in all cases. You want to
No.
excise that?
No. The portion that says continue with the following in all cases, I would give it because, well, this is a part of all cases. The paragraph I would excise is the one just before it, where it starts. It is the policy of this state to make an audio or audio and visual recording. I take that paragraph out.
In the brackets.
Yes.
Okay, I have no objection to that.
Okay. Then I'll move on. I'll give 190 weight of evidence, 195 jurors' knowledge. I would give 200 expert testimony general. So there's some selections that need to be made there, or at least addressed. It says continue with the following if experts have given conflicting testimony. I don't think that's the case, so I would propose to delete that portion. Any objection, Mr. Saunders?
No.
Mr. Freilich?
And the bottom bracket as well, the two brackets.
Right, that's the part that they're saying, continue with the following.
I'm just asking if you're going to take those out.
Yeah.
Okay, yes.
Okay, 255, this is the one, state need not prove exact date of commission, specific date alleged. That essentially says if you find that the offense charge was committed by the defendant, it is not necessary for the state to prove that the offense was committed on the precise date alleged in the information. If the evidence shows beyond a reasonable doubt that the offense was committed on a date near the date alleged, that is sufficient. You're asking for that, Mr. Saunders?
Yes.
Mr. Freilich, any objection?
Well, it's kind of a conundrum because they file a criminal complaint with one date, then they file the information, which is the charging document with a different date. But then they're saying they don't have to prove the exact date. So I'm kind of confused on that, Your Honor. So I have lodged an objection to that.
Okay, I'm going to give 255. I'm satisfied that the date in the information is the date that needs to be instructed because that's the charging document. But I'm also satisfied that this is an appropriate instruction to give in light of, frankly, the entirety of the evidence that I've heard. I'm satisfied that, frankly, given that the timing, the time of day that's occurring, that knowing when one day flipped to the next may not be so easy to pin down. So I'm satisfied this is an appropriate instruction. I'm going to give that as revised. I'm then going to give 300 credibility of witnesses. There is an option at the end that says give the following paragraph only when the defendant testifies. Given that the defendant didn't testify, I would propose to delete that and the bracketed paragraph just below it. And but then continue on with the last paragraph indicating there is no magic way for you to evaluate the testimony. Any objection to that, Mr. Saunders?
No.
Mr. Freilich?
No, Your Honor.
Okay. Moving on, 325, impeachment of witness, prior conviction or juvenile adjudication. I don't think anyone was asked that question, and I don't think anybody was impeached with a prior conviction. So I propose to take 325 out. Mr. Saunders, any objection?
No.
Mr. Freilich?
I agree.
Okay, that'll be out.
Thank you.
327, impeachment of defendant as witness, prior conviction or a juvenile adjudication. The defendant didn't testify. I propose to take that out. Any objection, Mr. Saunders?
No.
Mr. Freilich?
No, Your Honor.
That'll be out. 460, closing instruction, I would propose to give that. Then I would propose 484, verdict submitted for one defendant, 3 counts, separate verdict on each count required. I would propose to give 515, unanimous verdict and selection of presiding juror. And that's it. You'll have another opportunity to look at these after I've made those revisions, but such as they are, Mr. Saunders, any objection to the entirety of those instructions or anything I'm missing or that you'd like me to add?
Yeah, 2 additions that I'd propose. Madam Clerk, you have the copies. Okay, I have one for the courts and council. The first is based on some testimony that we heard. It'd be our request to make clear that voluntary intoxication is not a defense. In the case, there's not a pattern jury instruction that really says that. There's a part of 755A that does have that sentence, and the state would ask that just that sentence be read, given the state of the law and the state of the voluntary intoxication defense.
So you're saying this is coming out of 755A?
Correct. It's not directly applicable, but as modified, I believe it's accurate.
Take a look at it. response to their request for 755A. Just so you know, Mr. Freilich, and I know you don't have the benefit of having your computer sitting right in front of you regarding 755A. 755A is an instruction that is titled as follows: involuntary intoxication or drug condition. So it looks as if Mr. Saunders has utilized that pattern instruction. Mr. Saunders, if I'm correct, you've utilized that pattern instruction to craft this, and he's proposing that this be given. Any objection to that?
No, Your Honor.
Okay.
I know the law.
Okay. So that's fine. I will give this modified 755A. Generally, other than sometimes rearranging where the closing instruction goes, I give these in numerical order. That would put it right at the end. I don't propose to put it right at the end because the last one I generally give is 515, unanimous verdict and selection of a presiding juror. I think that is the best to have at the end. Proposal as to where we insert it, Mr. Saunders?
I would say right after the 115, the substantive jury instructions. That makes sense.
Any objection to inserting it there, Mr. Freilich, right after 115, the substantive instructions?
Your Honor, if I could just have the. Yes, that makes sense.
Okay. Very good. Okay, we've taken that one up. Then before I move on, do you have a Word document with these on it that
I
you
do.
can forward to my judicial assistant?
Okay.
One of you, so that because I'm going to be heading over there shortly to finish these off, and we'll need it. But let's look at, you don't have to do that till we're done, but let's look at your other request then, Mr. Saunders.
Yeah, so obviously that issue or this issue has been addressed in litigation. There was a motion to dismiss regarding the state doesn't need to prove that a crime victim was alive or deceased at the time of the sexual intercourse. And I think the state just envisioned a jury having that question, given the two elements don't clearly explain what I think is an accurate statement of the law. So our request would be to add something to address that issue, because obviously it's the facts and circumstances that the state's alleging in this case.
Okay. Well, let me just, before I turn to Mr. Freilich to take a look at his position on this, I'm just going to pull up the statute. Because we did have this issue that was raised as at the motion hearing on June 13th. This was heard by the court. And I know at that point I denied a motion to dismiss that count. And the assertion in that motion was that had been filed by the defense, that really the charge should be dismissed because at the time the alleged victim was deceased. And then we looked at the statute. Okay, and I know it. So the instruction, the one that I'm proposing to give in any event that everybody's agreed to, 1218A, references the statute 940.225 sub 3 sub A, and so I've looked at that statute, and under 940.225. Sub 7, it indicates specifically this section applies whether a victim is dead or alive at the time of the sexual contact or sexual intercourse. Okay, so what you're proposing that be done in this case, because of issues that have been raised and frankly that were argued on that date that it be inserted, that the following language be inserted. Quote, "It is immaterial whether Shad Thyrion is dead or alive at the time of the sexual intercourse," close quote. That's what you're asking to be added?
Yes.
Mr. Freilich, any objection to that language?
Your Honor, I know that the jury instruction says person. What about the statute? What we have here, and not to be crass, but human remains, body parts that are in different locations. So that was the issue that I had with that.
I'm sorry, your question, you said that the statute says person?
I know the jury instruction says person, but I don't know if the statute says that, but it talks about any part of a person's body. So it talks about a person. And what we have here is, a body part, body parts.
Statute says 3A says as follows: whoever has sexual intercourse with a person without the consent of that person is guilty of it's guilty of a felony. So the instruction mirrors the statute as far as person. So when you get down to sub 7, where it says this section applies whether a victim is dead or alive at the time of the sexual contact or sexual intercourse, they're using the word person, or using the word victim instead of person in sub 7, presumably because at that point in time, using the word person could get confusing as to whether you're talking about a victim or a perpetrator. If you just said the section applies whether a person is dead or alive, and you perpetrate, I don't want to get into all the machinations, but it would seem as if the word victim is used in sub 7, perhaps for that reason. So the question, of course, is whether there's an objection to insertion of the language, "It is immaterial whether Shad Thyrion is dead or alive at the time of the sexual intercourse." Any objection to that?
I know that's in the statute, but is that in the pattern jury instruction that we have, Your Honor?
It is not.
It's not.
He's asking for it to be added in.
Yeah, he wants to add something, correct?
Yes.
I'm going to object to that.
Okay. I'm satisfied that, first of all, adding that language in is a correct statement of the law. It is. It's not as if modifying the instruction to something that's incorrectly outlines what the law is. It's an accurate statement of the law. Secondly, this is a bit of an unusual circumstance where typically when you see these assaults occur, you have someone in court testifying that they were the victim of a sexual assault. That's different, of course, when you have someone who is deceased. So the circumstances of this case are a little bit unique. It's already been put into this case. It was argued, and I'm satisfied that it's an appropriate addition in this particular case. These pattern jury instructions are not by any means mandated by law to be used. They're guides, and while we usually follow them, it's certainly permissible for courts to look at them and modify them as needed, and I think this is an appropriate addition. So I'm going to grant that request. And so that will be added to instruction 115, the subpart under 1218A. Anything else, Mr. Saunders?
No, thank you.
Right, Mr. Freilich, again, you're going to get a final opportunity to review these. At any additions or changes that you're looking for besides what we've already discussed?
No, Your Honor. Thank you very much.
Okay. Let me just ask you then about the proposed verdict forms. Obviously, there are 3 counts. There will be 6 verdict forms, 1 for guilty and 1 for not guilty for each count. Mr. Saunders, have you had an opportunity to review those?
Yes.
Changes or corrections on those?
No.
Mr. Freilich?
One moment, please. Your Honor, I have reviewed all the verdict forms. They appear to be in proper order.
Okay. My judicial assistant and I are going to get underway on these right away. Mr. Saunders, if you can make sure you send a Word version over to her. I invite the attorneys to get up and move around if you want, but don't get far, because as soon as I'm done, I want to get back on the record. And I don't know how long it's going to take me. So just stay close, but you can certainly move about the courthouse, okay?
Thank you.
We're in recess.
Okay, well, I just asked over in Law and Crime about how long the break was, and nobody responded. So let's rewind a bit and listen.
One for guilty and one for not guilty for each count. Mr. Saunders, have you had an opportunity to review those?
Yes.
Changes or corrections on those?
No.
Mr. Freilich?
1 moment, please. Your Honor, I have reviewed all the verdict forms. They appear to be in proper order.
Okay. My judicial assistant and I are going to get underway on these right away. Mr. Saunders, if you can make sure you send a Word version over to her. I invite the attorneys to get up and move around if you want, but don't get far, because as soon as I'm done, I want to get back on the record. And I don't know how long it's going to take me. So just stay close, but you can certainly move about the courthouse, okay?
Thank you.
We're in recess.
Okay, so that's why I didn't catch it, because he didn't give a projected time frame. So, well, it looks like somebody else just tuned in. Indiana hasn't been reading her messages, so let's see. This could be any length of time at all, so whatever I go to might end abruptly. Oh, this has nothing to do with crime, but it does have to do with crafting. Dollhouse makeover. We found it in a dumpster, fixed it up, and gave it away. I'll have to watch that. Oh, somebody in law and crime chat said Sinead O'Connor died. I haven't heard anything about that. She seems awfully young. Yay, Indiana! Yeah, we're gonna have closing arguments here soon. And a verdict watch, which I think will be very short. I think 15 minutes ought to do it. They might take an hour just to not look too hasty, but I can't remember how long did the Waukesha verdict take. 56. She's younger than I am. Oh my. So let's see what else is in the news. Uh-oh. I follow a vlog with some English expats who are renovating properties in France, and they just posted a video 15 minutes ago saying convent basement completely flooded. First, they bought a chateau and were featured on Escape to the Chateau, which is one of the spin-offs from Escape to the Country. And then his wife inherited some money, and so they decided to buy this convent. And they've been working on it for a year now, and they've decided they're going to renovate it and turn it into a hotel. So I've been following that because it's so fascinating. So let's see. I love old buildings. And a bunch of us in the comments on that vlog say, "Oh, we all want to do that, but we're all too old and can't handle doing the task." And so I was going, "Oh, we need to club together and buy one." And so it's like, "Oh, great! It can be a chateau commune." So let's see. Oh, I don't know how Split is. It's a parody of Harry and Meghan with this comedian who does all the parts, like split personality. And he's got an episode that just came out today on the Air Force One thing. But I don't know if I air it if I'm going to get struck. It's only 4 minutes and 26 seconds. Maybe I'll pull it up, and if I get struck, then I will edit it out. So let's set this up. Oh, I need to. Okay. Okay, let's get everything set up. Here we go.
Oh, just want to suggest that at the end of the video, you leave a comment.
We just thought it would be a quicker and more, like appropriate way of getting to the UK, after the sad news of the Queen's passing.
Well, thank you for confirming that this story is indeed true. I, for one, thought there were limits to your behavior, lines below which you would not sink. But it appears not, as this action was astonishingly crude, ridiculous, hubristic, and insulting, all in equal measure. No, I was just distraught with grief, and I just wanted to get over there, well, over here, I suppose, as quick as possible.
And in a mode of transport that was more befitting, our status as the only, UK royals living in the US.
A former colony, don't you know? Yes, Harry, what an excellent way to ingratiate yourself to your fellow countrymen.
And even though, I'm thoroughly ashamed to be an American, but I still thought it had enough respect for us, indeed for itself, to let us borrow Air Force One, just for a short time, to get to where we were needed.
But Jill Biden, Dr. Jill Biden apparently vetoed the idea. Well, rumors are that they didn't trust you not to go snooping around and then leak what you found to the press.
Oh,
why on earth would they think that? Well, you do have form. She's not a real doctor, don't you? Dr. Jill Biden, not a real doctor. No, I wouldn't play that game if I were you two. Why not? Well, you're not a real prince, Meghan's not a real duchess, and neither of you are real talents. Good point.
We are getting some feedback come through, right? And one of the most common criticisms seems to be that we were disrespectful somehow by not honoring the proper, solemnity of the situation, following the death of the Queen.
Yeah, and apparently it's insulting to expect the US taxpayer to fund the chauffeuring of, basic nobodies across the Atlantic.
And do you think they have a point? No.
No?
Not at all.
Probably. Well, it does appear to a neutral observer that your immediate reaction to the death of the Queen was to try and boost your own profile. Well, had you have arrived on Air Force One, it would have, well, maybe not overshadowed the Queen's death, but it would have been a major talking point at a period where all the proper focus should have been on the Queen's legacy. Well, many people at home, and I won't read the messages because I know that Harry wells up quite easily, were quite shocked that even at a moment of profound sadness and, as you said, solemnity, that your default reaction was one of self-promotion. If you're in the game, you've got to hustle.
Grifter's gonna grift.
The White House's swift denial of your request must indicate to you the sheer level of gall, of nerve encapsulated in your petition. I mean, the US taxpayer must be shocked to learn of your cheek. And had you have actually arrived in London at that sad time on Air Force One, well, the UK taxpayer would have never forgiven you. I mean, you would have simultaneously ruined your relationship with both countries. Well, we are fond of efficiency.
I really don't know, right, what the big deal is. I mean, we were just two individuals who were desperate to get to our loved ones, after the passing of our matriarch, our beloved matriarch. I thought people would at least be able to see the human side of this, the human level.
But after you were refused, why didn't you go with Harry anyway?
Because if I'm not going to go on Air Force One, then I'm not going to go at all. I mean, we'll just arrive in some common old private jet. What's the point?
That was the video. If you wouldn't mind liking, subscribing, hit the comments and the notification bell. Fabulous. Do it all. Thanks.
Okay. Oops, let's see. Let's go back over to the CO while I look to see if there's something else that's short. Oh, I forgot. I was going to put the link in the description. So let me... Let's do that while... That usually helps to get on people's good sides if you're sharing their material, as if you put a plug in them. Okay, that's done. Now let's see what we've got. Oh, here we go. Let's see.
His birthday, and Van LeChimp, one of the Grizzly team members, made this beautiful art for us. Happy birthday to Dominic. Also, today, Ronald Anthony Burgos Aviles, the former Border Patrol supervisory officer who murdered Dominic and his mother, has now arrived in the Huntsville prison in Texas. Today, he literally arrived this morning. And so, finally, we get to see him in his orange prison outfit, just like we wanted to. And we know that now he's in his forever home. 2 consecutive life without parole sentences is what he'll be serving. And I don't think he's going to be very welcomed, being former law enforcement and a baby killer. So, what do you feel? I think justice has been served. And again, happy birthday to Dominic Hernandez.
Let's watch the...
Today is Dominic Hernandez's birthday, and Van LeChimp, one of the Grizzly team members, made this beautiful art for us. Happy birthday to Dominic. Also, today, Ronald Anthony Burgos Aviles, the former Border Patrol supervisory officer who murdered Dominic and his mother, has now arrived in the Huntsville prison in Texas. Today, he literally arrived this morning. And so, finally, we get to see him in his orange prison outfit, just like we wanted to. And we know that now he's in his forever home. 2 consecutive life without parole sentences is what he'll be serving. And I don't think he's going to be very welcomed, being former law enforcement and a baby killer. So,
Okay, let's go back over to the seal and see what else we can find. Yeah, well, that's just such a darling photo that somebody made. Okay. don't want to do anything too long. Although I suppose if we do start something and we have to go back, we can always pick up later during Verdict Watch. Michelle After Dark has an episode, Fangirling Dahmer, which I haven't had a chance to watch yet, and that ought to be quite interesting. Let's see. Oh, I remember. I saved something. Let's look at my playlist. Okay, here's one of the videos. It's probably something we're going to need to come back to. Let me just get it set up.
To kill her 3-year-old son.
What?
To kill her own child.
To kill her own child? I didn't get that far.
A young mother is in jail in Miami, Florida, after police said she tried to hire a hitman to kill her son on a website. Welcome back to Sidebar here on Law and Crime. I'm Anjanette Levy. Police say Jasmine Paez used the website hireahitman.com to try to hire someone to take out her young son. The website is a parody site, though, so the owner turned Paez into police.
So the intended victim, I guess, was her child. She's 3 years old.
According to the arrest form, the child is in the custody of the grandmother, I believe.
That's a good thing. Ms. Pius, have you ever been treated for any type of mental health condition?
No.
According to Miami-Dade police, a detective posed as a hitman and sent a text to Paez. Police say she responded by sending a photo of her son and agreed to pay $3,000 for the boy to be taken far away and killed. Paez's father is defending her, telling a TV station in Miami, quote, "My daughter is not a monster. My daughter is a little girl who was born with health problems. She has liquid retained in her neck. She's had 12 surgeries. She lost the ability to move her face. She's been bullied in school. They called her the monster." Paez's father believes the justice system will flesh out the truth in the case. Meanwhile, the judge ordered Paez to not have any contact with her son whatsoever.
I'm ordering that you stay away from your 3-year-old child. I think it's her son, whose initials are CGP. No contact with this child, either directly, indirectly, in person, in writing, by telephone, or through third parties. And no contact with the victim through social media or other electronic means. And you must stay at least 500 feet away from the victim, his home, school, or daycare at all times. Do you understand that? I can't hear her, Ms. Corey.
Yes.
And a neighbor who wants to remain anonymous told CBS Miami, quote, "I've never seen anything like this. To do something like this, what could be going through her mind? She's so young." Joining me to discuss this disturbing situation is Bob Inez. He is the owner of rentahitman.com, and also he is the person who called Miami-Dade police to report this. Bob, welcome to Sidebar. Thanks for coming on.
Thank you for having me.
Bob, I have to ask you right off the bat, why on earth do you own a website called rentahitman.com?
Well, it was initially registered in 2005 for an IT security startup specializing in penetration testing, network risk analysis, with HIT being the key word. At the time, there were 4 of us involved in this startup. So rent doesn't hire us, HIT pertaining to network traffic, analytics, and that kind of thing. And men, well, again, there were a couple of us involved in the project. Business plans were never fully executed, you might say. And I was left holding on to the domain. And in the years following the failed business, I had tried to auction the website several times on different platforms, and there were no buyers. In 2010, I received a very disturbing email from a female stranded in Canada. She was from the UK. She had no passport, and she wanted to have 3 family members murdered. It was after that incident that I realized that the website had prevented the murder of those 3 people. And that's when it was basically reformatted into what it is today, a website where nobody can be stupid enough to hire a hitman online. And I'm proven wrong by that daily.
Yes, you've been proven wrong, it sounds like, time and time again.
Yes. Yeah, it's pretty scary. I don't seek these people out. These people are looking for a hitman online, and they ultimately find the website.
How many people submit queries or what have you to your website weekly, do you think, just ballpark, who are just kind of joking around? And how many of these queries are serious?
Well, I have to say, in the last couple of weeks, the website's been hit with a lot of people just testing out the web page, the service request form. But on average, on an average month, it would receive about 200 service requests a month that were credible in nature, that there was enough information to look into further. And only about 8 to 10% of those actually end up turning into anything like a welfare check or perhaps for further investigation.
So let's go to the Miami-Dade case. When did you realize that Jasmine Paez, or at least someone claiming to be her, you know, she's saying she didn't do this, or at least her father is. When did you realize, wow, this person is serious?
Well, the first thing that tipped me off was the picture of the child and the date that she specified she needed this done by. You know, so we were under time constraints immediately once the request was received. As soon as I started verifying names and addresses, that's when I became very real and had to act on it.
So you call Miami-Dade police and you try to report this.
Tried to report this a couple of times to them. The first couple of phone calls, I was told to reach out to Crime Stoppers 305, I believe it is. And it was on the 3rd or 4th phone call that I finally escalated it to a supervisor who I was able to explain the details to. And that's when they took it seriously and passed it on to the sergeant and detectives.
So you felt like in the beginning they were just kind of pushing you off, because if you were to call in a Crime Stoppers tip, in some instances it goes to, you know, a switchboard somewhere else. They forward the tips. There's a lag there.
Yeah, definitely. Yeah, I tried to express the importance, the significance of, you know, the child's involvement, being the alleged target. And, you know, Crime Stoppers just wasn't going to cut it. Yeah, you mentioned the lag. I knew that. I was aware of that. And this couldn't wait.
What was her request to you at first, like the opening request?
The opening request. So basically, she specified on the service request form that she had to have that she wanted to have the child taken far, far away and possibly killed. That was pretty much it. That summed it up. I knew what I needed to do at that point.
So after the police take you seriously, what happens? Do you just pose, or do they pose as the hitman? How does this move forward?
So once a service request is received, and that's what I call it, a service request, I'll send out an email, a response email, and I'll just ask, do you still require our services, and would you like me to place you in contact with the field operative? If the email bounces, or if they say no, maybe they have figured it out, or maybe it's a bad address, maybe it's just a hoax lead, and that kind of gets filed in one bin, you might say. However, she responded back with yes, indicating she wanted to have a field operative contact her, ultimately granting permission to take it to that next level. So that's just what I did.
And what happens from there? It's my understanding that police, obviously, they sort of take over and they apprehend her.
Yeah, so during the course of the investigation, I put together a statement of what she said according to the web form, and I kind of corroborate that with information that I'm able to find as far as names, addresses, and whatnot. I pass it all on to somebody in law enforcement. The information provided does include the IP address of the submitter, and law enforcement was easily able to verify the IP address with the subscriber account and address where she lived. So, it's in their hands to investigate, and they have the opportunity to do a welfare check and make sure the child's okay, or B, act as the hitman and take over at that point and contact her. And I guess that's what they did in this particular case. They called her and said they were a representative of the website and verified what she wanted to have done. So.
Well, she has appeared in court already, and the judge even seemed shocked by this. Like her reaction was she was taken aback. I mean, you don't hear about something like this, and thank goodness that child was not harmed as far as we know.
Yeah, so fortunately, the Miami-Dade authorities acted. They took it very seriously. They made sure the child was okay, that's number one priority for me, is to make sure that everybody comes out of this okay. I have the highest regard for Miami-Dade and how they handled this.
Bob, how many times have you reported something to law enforcement and someone was actually arrested and charged for their query and for trying to arrange something like this?
There have been many cases. I don't have an exact number, because typically when I report something like this, I just grab a case number for my records, and there's not really any follow-up unless investigators have a question. However, since the website has been in the spotlight, I guess, and the media's attention recently, you're seeing more and more cases that have made the news. On average, about 15 requests or so each month end up getting referred to law enforcement. I'm not sure if all of those end up in an arrest. Again, I don't follow up in that capacity. But it's averaged about 15 a month for the past year and a half or so. That's quite a few.
Most certainly, especially if these are people who are not just messing around and think this is a joke. People who are actually serious about this. Very scary.
Well, I try and sort out the hoax inquiries too. I'm actually, pretty good at that, if you ask me. The site receives a lot of requests for, like, SpongeBob, and obviously these are kids that are just filling out the form and just kind of playing around. those are easy to pick out. It's the inquiries that have information for both the solicitor and the target. And if I'm able to corroborate any of that information, that is kind of a red flag. And that's when I look into it more seriously. So.
Bob Inez, owner of rentahitman.com. Thank you so much for coming on to talk with us about this. I'm so glad that your tip finally was taken seriously and something horrible was likely prevented.
Yes. Thank you for having me. I am, as long as these tips keep coming in, as long as these service requests keep coming in, I'm going to continue to work them the best that I can and, hopefully save additional lives.
That's it for this.
That gave him permission to use the car. His mama reported him missing. I popped the trunk, saw there's a dead body in the trunk.
On July 29, 2020, shortly before 5 p.m., a Louisiana state trooper conducted a traffic stop involving a 2017 Chevrolet Camaro on Louisiana Highway 17 near Williamsboro, Louisiana. The vehicle was doing a 73 and a 55.
F39, Region 3.
Region 3 at 39.
LA 17, 1 mile south of LA 4. Black and orange Chevy Camaro 242 Charlie Lima Tango 242 CLT Louisiana.
F63 Region 3, I'm 10-8.
Hey, driver. Hey, driver. Hey, sit back here with me, man. How are you? Hey, good afternoon. I'm Trooper Nielsen, Louisiana State Police. The reason why I stopped you was for speeding. You know how fast you're going?
No, sir.
73 and a 55, so it's 18 over the limit. Do you have your driver's license?
No. No, sir.
Do you have a driver's license?
No, sir.
And why are you driving?
I was just
Okay.
going home.
Do you have any weapons on you?
No, sir.
It's okay. I was just asking. What's your name, man?
Michael.
Michael. Is anybody with you?
No, sir. It's just me.
You have insurance? All right, show me your insurance. Whose car is this, man? Your big brother's? You smoking weed today? Look at me.
I did early. I'm not high right now.
Okay. All right, we'll take a look at you. Do you have an ID? You have any ID? Is there any weed in the car, man? Don't stop. Step here. Step here to me. Look at me, Michael. Make eye contact with me. Step out here. Step up here. Is there any weed in the car? Yes or no?
It's just a doobie in the ashtray. Like,
okay.
Other than that, there's
anything else?
There's
all right. You be honest with me, I'll be honest with you. I ain't looking for no roach. You hear me?
Yes, sir.
Is there anything else in there?
Yes, sir. I promise.
Okay, it's in the ashtray? In that
Yes.
cup thing?
Yes, sir.
Anything else?
Yes, sir.
Okay. When did you puff last?
This was
Be honest. Because I'm a drug recognition expert.
about an hour ago.
Okay. Okay. I'm gonna look at you. But all right, where are you headed right now?
I was headed back home.
Okay. Where's home? What's your address? Oh, stop. Come here. Where do you live? It's easy. It's easy to answer this. Where do you live? You don't know how to drive to your house?
I was coming from there. How I got lost.
So what's the address?
No.
What? You don't know your address?
No, sir.
Okay, come back here. Come back here. All right. Prop up on this bumper right here, okay? Just sit down right here, okay? All right. All right. You've admitted there's a small amount of marijuana in the car, and I've smelled it. It's probable cause. Can I take a look in your car? It's yes or no?
Yes, sir. Yes,
okay. Okay. Nothing. Okay. It's your brother's car? It's your brother's car? Hey, come here. Put that phone on that hood. You know you ain't gonna sit here and be texting behind my back while I'm sitting here in this car. Get on that car. All right, now step here. When did all this happen? When did all that happen?
That happened.
When?
My brother, he said it.
How long ago?
Like
Days?
yeah.
Okay. Come back. Just lay this here. Come back here. Just stay right here in front of my car. Is this your wrench?
No, sir.
Hey, Jeff. Hey, it's Jesse again. I'm sorry to bother you. I'm here about a mile north. About a mile north of LA4 on LA17. I got this. I got a orange and black Chevy Camaro stopped. I had him stopped for speeding, 73 and a 55, and it's got bullet holes all in the driver's side, right by the door. Y'all ain't looking for a car involved in anything. Hold on, just let me run this date of birth. Yes, sir. And he don't even know where he lives. He won't, or he's saying he don't know where he lives. Well, I just making sure. I mean, he's saying he's saying he lives down here in Winsboro, but his address is coming back out of Richwood. But
Yeah, 41
he don't even know the address down here, but like right behind the driver's side door, there's like 2 or 3 bullet holes in that thing.
41.
So he said two or 3 days ago, his brother, the is the name on the car, on the registration. Okay, I'm gonna call a guy. I mean, I'm code 4. I was just seeing if y'all had this connected to anything down here. Yes, sir. Okay, all right. Yeah, I'm north of 4. Not even I'm right by the golf course. All right, bye.
Region 3. 832. 9 westbound. Light Toyota Sequoia. Foxtrot Zulu Tango.
All right. I just wanted to see if y'all are working anything or looking at anything. I'm a mile north on LA 17 over here north of Winsboro. On just north of LA 4. And I got this car speeding 73 and a 55. It's a black and orange Camaro. And it's got like 3 bullet holes in the left side of it. In that Camaro, that little triangle window right behind the driver door, and right in the door jamb, there's a round, and there's like 2 right behind that. And he said he thinks his brother said his car was in something 2 nights ago. Now he says he lives in Winsboro, but he's got a Richwood address, and the car comes back out of Monroe, and he's got this he's got a GPS thing put in, but he don't even know the address, so he's lying about a bunch of junk. So I was just gonna check y'all aren't working anything up. Yeah. Okay.
His family in Monroe is looking for him. They sent me out here.
Okay. All right. Well, I got somebody pulling up behind me scooter. All right. Thank you, fella. Hey, now. Who are you?
They don't scare me to deal.
Well, how are y'all here?
Cause my people from Monroe, that's them on the phone.
What do you mean they were looking for him?
They looking for him. The car missing. Hey.
Okay. Give it a call. Hey, man. Okay. What? His name is Mike. He's not giving that name though. He's given another name.
I got to go back to work.
What's your number, sir? His phone back.
Yeah, I got to go back to work.
Okay. He said he needs his phone back. I'll call you on a block line in a minute. Okay.
Okay, I'll show thank you.
Okay. Thank you. All right. Let me ask you something. Did you give me your right name?
Yes, sir.
What's your name?
Michael.
You got plaits in your head?
No, sir.
Okay. Where do you live? Be honest to me. Monroe?
Yes, sir.
Richwood?
Yes,
you don't live in Winsboro?
No, sir.
Why would you try to bluff me on that? Why would you lie to me on that? Because I already knew that before this guy said something. What's up? Talk to me. You better stop lying to me right now or you're going to be in jail.
I'm just going to my sister's house.
To your sister's? So when I kept asking you where you live, you don't even know because this ain't even your house. You better get some act right in you and stop lying. Some act right in you and stop lying to me, or I swear to God, you're fixing to go to jail. Do you understand?
Yes, sir.
That's the last freaking lie you better tell me. What's your last name? Who took the car? Who took that car from whoever it belonged to?
He gave me permission for the car.
Mike gave you permission to drive this car?
Yes, sir.
Who gave him permission?
This is what.
Say with him, please. How are you? This is Chad. Hold on just a sec, sir. F-39 Region 3. I've got a Franklin Parish unit out with me. I'm with Code 4. Hey. All right, sir. What's your name? What's your name? Okay. Has this car been reported missing? Okay. Who? Okay, let me ask you something. Has the car been reported stolen, missing? Who are you talking to at the police department? Who do I need to talk to that knows? Yes, sir. Okay, give me the number. Hold on a second. Go ahead.
1012. Call Franklin Echo in reference to your stop.
Okay, what's the number, sir? Tiffo. Okay. Well, sir, I'm gonna have to call you back. I got too many people out here. Is it Monroe Police Department? Okay, I'll talk to them. All right. Let me go. All right. I'll call you back. Bye bye. Hey, this is Nielsen out here. Hey. Yeah.
Give him a call at the office.
It's orange. It's black with orange stripes. I just had this guy said that there's a kid that's been reported missing, and that they took the car from Monroe, and he lied to me about his last name. I mean,
A person may be considered as evidence. Whether the statement was actually restated here at trial, and whether the statement or any part of it ought to be believed. You should consider the facts and circumstances surrounding the making of each statement, along with all of the other evidence in determining how much weight, if any, the statement deserves. The weight of evidence does not depend on the number of witnesses on each side. You may find that the testimony of one witness is entitled to greater weight than the testimony of another witness, or even of several other witnesses. In weighing the evidence, you may take into account matters of your common knowledge and your observations and experiences in the affairs of life. Ordinarily, a witness may testify only about facts. However, a witness with specialized knowledge in a particular field may give an opinion in that field. In determining the weight to give this opinion, you should consider the qualifications and credibility of the witness, the facts upon which the opinion is based, and the reasons given for the opinion. Opinion evidence was received to help you reach a conclusion. However, you are not bound by any witness's opinion. If you find that the offense charge was committed by the defendant, it is not necessary for the state to prove that the offense was committed on the precise date alleged in the information. If the evidence shows beyond a reasonable doubt that the offense was committed on a date near the alleged date, that is sufficient. It is the duty of the jury to scrutinize and to weigh the testimony of each witness and to determine the effect of the evidence as a whole. You are the sole judges of the credibility, that is, the believability of the witnesses and the weight to be given to their testimony. In your determination of credibility, you must avoid bias, conscious or unconscious, based upon the witness's race, national origin, religion, age, ability, gender identity, sexual orientation, education, income level, or any other personal characteristic. In determining the credibility of each witness and the weight you give to the testimony of each witness, consider these factors. whether the witness has an interest or lack of interest in the result of this trial, the witness's conduct, appearance, and demeanor on the witness stand, the clearness or lack of clearness of the witness's recollections, the opportunity the witness had for observing and for knowing the matters the witness testified about, the reasonableness of the witness's testimony, the apparent intelligence of the witness, bias or prejudice, if any has been shown, possible motives for falsifying testimony, and all other facts and circumstances during the trial which tend either to support or discredit the testimony. Then, give to the testimony of each witness the weight you believe it should receive. There is no magic way for you to evaluate the testimony. Instead, you should use your common sense and experience. In everyday life, you determine for yourselves the reliability of things people say to you. You should do the same thing here. A defendant in a criminal case has the absolute constitutional right not to testify. The defendant's decision not to testify must not be considered by you in any way and must not influence your verdict in any manner. Consider carefully the closing arguments of the attorneys, but their arguments and conclusions and opinions are not evidence. Draw your own conclusions from the evidence and decide upon your verdict according to the evidence and under the instructions given to you by the court. We're now ready for the attorneys to give their closing arguments. I want to speak briefly, however, to both the attorneys that are giving the closing arguments, if you could approach. And ladies and gentlemen, in the event you were wondering, you are going to get a copy of these instructions during your deliberations, because I know they're lengthy. Having said that, Mr. Saunders, are you prepared to give a closing argument?
Yes, Your Honor.
Very good. Go ahead.
Good afternoon. I want to start with something that we heard yesterday, or actually Monday, during opening statements. Counsel told us that there's always two sides to every story, and with all due respect, this is not one of those stories. This is a story that pretty clearly shows what happened. It's a story of the defendant taking a dog collar that was around her friend's neck and pulling it so hard and for so long and with such force that it caused his death. That in that moment, she made a deliberate choice to end her friend's life. She then, after the fact, degrades his body, engages in sexual acts with him. This is a story of the defendant then dismembering him and leaving his remains all over the house for his mother to find. And this isn't the state's story. This isn't law enforcement's story. It's the defendant's story, as you heard today, right? So as we go through this, it's easy to sit here and say, yes, the defendant confessed, and it's true. She confessed to every single element that you will see that the state needs to prove. But we didn't just stop there, right? We could have been done with this case on Monday, played her interview and called it a day. But you should expect more, right? We have the burden of proof, and obviously we called a number of witnesses to establish what this story shows. So I want to walk through that story. And I know there's a lot of law that was just read to you, but I'm a visual learner, so I like to see kind of what we're looking at here. So as I go through these three offenses, there's really, as you'll see, 6 things the state needs to prove beyond a reasonable doubt. Not every fact that was testified to, not what time somebody got to Scott Holmes' house at the end of the night. The 6 elements are what the state needs to prove to you beyond a reasonable doubt, okay? So first, count 1, first-degree intentional homicide. First, that the defendant caused the death of Shad, and that she, second, acted with intent to kill him, okay? And again, as I already mentioned, as we go through these elements, you heard earlier this morning that the defendant is acknowledging every element that we hear, okay? Independent of the information you heard today, With the investigation you heard, the DNA, the other information, Dr. Tranquita's testimony, I would argue would prove all these elements as well. But you have on top of that the defendant's admissions to all these elements. Okay, so the defendant caused the death of Shad. And that should be fairly clear here. Obviously, she admits that. You heard Dr. Tranquita's testimony of how Shad died, the cause and the manner of death, strangulation, excessive force being placed on the neck, producing his death. That was the sole cause of death that we heard. So let's talk about intent, right? Because that admittedly sometimes is a tricky topic, right? We can never know anyone's intent truly. And as you're told, you're not going into the mind of somebody, right? Kind of looking at all the facts and circumstances that you see. In this case, you have the benefit of the defendant opening up her mind to you and telling you what her intent was here. But you also have other signs, right? So what does intent mean? That somebody had the mental purpose to do something, right? Some volition. Or that they're aware that what they're doing is practically certain to cause that result, right? And you heard both, really, from the defendant. So I want to walk through that because there's a lot of points in that interview where the defendant is telling you exactly what her intent was in this case, right? His face was turning purple, right? She describes that and how he's coughing up blood. And you know that's accurate, right? Because you heard Dr. Tranquita's testimony. And you saw those photographs. She's seeing that in person, and yet what does she say? I still didn't stop. No, she felt a heartbeat at one point, right? She talks about feeling his heartbeat, and she kept pulling more, and he wouldn't die. And I just wanted him, and I was like, damn, right? She admits even that Shad's struggling in this moment, that he's fighting back, right? You heard from Dr. Tranquita as well about how it looked like at one point there were signs of that where the collar slipped up along the tongue. She's telling you, I was waiting for him to die. I liked it. She figured I'm already this far, and she's pantomiming the act. It's like she's starting a lawnmower. That's how hard she's pulling on this chain, right? Took 3 to 5 minutes, she thinks. And again, that's consistent with Dr. Tranquita, right? This is not an accident. This isn't a whoops. This is an intentional act, right? We don't need to prove that she went to that house with this intent, right? We talked about that in voir dire. And we kind of talked through that concept of how, as you're instructed, intent can be formed in the instant before an act, the instant before the pull of a trigger, the instant in this case, before Ms. Schabusiness decides, I'm going to go further and pull on this chain so hard that it causes the result that we saw in Shad, right? So we have the mental purpose, right, from the defendant's own mouth, and that's consistent with everything else we're seeing in the case. But you also have Detective Kempf asking her, I mean, in that moment, did you kind of realize if you kept pulling on that chain that he would die? She's like, probably, yeah. Yeah, she was aware of that, right? So that goes to this kind of the second either or part of intent, right? Was aware that her conduct was practically certain to cause that result, and it's probably obvious as you sit here of what's going to happen when you're pulling a metal chain like that hard for that long, seeing the result of what's happening to another person, that is going to be the result, right? So you're told you can't look into a person's mind. The defendant told you exactly what her intent was in this case. But as I mentioned, you also have other indicators, right? You have Dr. Tranquita's testimony describing the amount of force that would need to have been done to cause the injuries that he's observing, right? Down to the inner neck muscles. And he was talking about how strong and thick those neck muscles are. And there was hemorrhaging that deep. That's how hard and how long and how much injury the defendant was causing, right? This isn't an accident. If it's an accident, you're not going forward. You're not seeing this result and keep pulling. You're calling for help. You're stopping. You're certainly not after the fact, after you finally finish, then cutting up his body, right? You have all the evidence in this case points to intent, right? You have her acts after the fact, like I said. If this was an accident, something happens, right? You call for help, and you have the exact opposite. You have the defendant cutting him up and cleaning up, getting rid of the remains, pouring it down the shower. We heard a lot of testimony about that. Kind of wiping up with the Clorox wipes, which the defendant is acknowledging as well. So you have the defendant's statement in the case, and it lines up with everything else in the case, right? Even little facts that she's remembering and telling you about, right? The timeline of the February 21st night, right? We heard from AJ Gannon, you heard the stipulated testimony from Mr. Tomes, you heard from Mike Thyrion. It's all consistent. Yeah, they were coming and going. You then heard from Steve Hendricks about, yep, they got back sometime in the early morning and I let them in. Defendant's telling you that same thing. Steve is talking about how at one point during the day on the 22nd, she comes up and asks for her eyeglasses. We heard the defendant talk about that as well. We heard Detective Graff testify about that. So everything she's saying is consistent with what we're objectively seeing, what law enforcement is finding. And in some respects, the defendant's leading the investigation, right? Because when they get there, when law enforcement gets there, we saw Officer Wanish's body cam. We heard from Detective Scanlon and even Dr. Tranquita about how it was really hard to determine what exactly happened when they first got there. And all that information is being provided by the defendant. Okay. So it's an intentional act. She had the mental purpose. We heard about that. It's not, as I talked about, it can be formed at any time before the act, right? It doesn't need to be premeditated. That's not the law in this state. And it's really important too to not confuse this with motive, right? We heard evidence about motive, right? And her interest in Jeffrey Dahmer and all that entails. But intent doesn't mean motive. This is what intent means. And we proved intent, right? She caused his death and she acted intentionally and she told you as much. So those are the two elements. Those are the two things the state needs to prove beyond a reasonable doubt. Count two, mutilating a corpse. So again, there's two elements for this crime. First, the defendant dismembered a corpse. Second, did so with the intent to conceal a crime. So the first element, I think, is pretty clear, right? And we heard extensive testimony from many people, and we saw Dr. Tranquita's diagrams, and obviously I can't imagine this element is going to be in dispute, right? And so again, though, we have this concept of intent, of the purpose to conceal a crime, right? And I mean, as you're instructed, you use your common sense. Like, why is somebody going to this length, not only cutting up a body? We heard from Dr. Tranquita about the multiple sort of start and stop kind of signs, the total evisceration of Shad, bagging him into other bags and attempting to carry out. Like, that's the intent, right? We use our common sense that's why you're doing that. But again, she was asked about this, the defendant. And remember in that February 28th interview, the second interview with Detective Graff and Detective Scanlon, she's saying exactly what her intent was, right? It was because there's other people in the house. Like, what am I going to do? Leave the body and have mom find it? She admits, again, this was her intent, and it's obvious with our common sense, but it shows that the state has proved both elements of this crime as well. Okay, count three. It's third-degree sexual assault. So the defendant had sexual intercourse with Shad and did so without consent. So let's talk about the first part. Sexual intercourse is defined in the state as inserting any object into the genital or anal opening of another, or engaging in oral contact with the penis. We heard about both, right? The defendant admitted to both. She's talking about how she's put the dildo in Chad's anus after she killed him. She's talking about how she was sucking on his penis, and there were other phrases used to that effect. So again, we have, for both elements here, the defendant's admissions. And we heard from Mr. Scott, didn't we? We heard from Mr. Scott about the DNA testing that was done, right? And for some of the reasons why even though the defendant's DNA is on that dildo in Shad's house, Shad's DNA wasn't found on there, and nothing excludes that possibility. And again, everything the defendant's telling you is consistent with other things you're seeing. So there's no reason to believe, a reasonable hypothesis to believe, that she's not also telling you what's happened in this case too, right, for this count. And the second element, did not consent. I mean, that, as you're instructed, is kind of inferred by the fact that at the time that the defendant's telling you she's engaging in these acts, that Shad's deceased, right? So he's not in a position to consent. Okay. So those are the two elements for count 3. So in total, 6 elements for the 3 offenses. And again, you're given a lot of law on how to assess credibility of witnesses, and that's good, and you should follow it. Really, you kind of just use your common sense as jurors. And again, the defendant's telling you what happened, and there's nothing in the case to disbelieve what she's saying, right? So you have the defendant's admissions, as I mentioned earlier. There's other evidence that kind of just only should bolster the conviction in the defendant's guilt, right? We heard from Kevin Scott, who heard or testified about the DNA testing he did. Shad's blood on the defendant's hands, on her clothing, on the sweatpants, about how the knives that were found that had Shad's blood on them, right? Even absent her confession, I mean, there's ample evidence here to convict on all 3 counts. You have many witnesses coming in to talk about the integrity of the investigation, how law enforcement didn't just take the confession and go home, right? We do more, right? Send things in for DNA, we speak with other witnesses, we corroborate the defendant's timeline of things. You heard all that. And that's really important, right? We have the burden of proof. We talked about that, and we embrace that burden of proof. You should hold us to that standard as the state to prove something beyond a reasonable doubt. And that's why we call people from Madison to come up to talk for 5 minutes about, I received this piece of evidence and it was fine. And I returned that piece of evidence and it was fine, right? Because it's important. We want to show that law enforcement did a thorough investigation in this case. And they did. Because we have the burden of proof. You're instructed on what the burden of proof is and what it's not, right? It's a reasonable doubt, a reasonable hypothesis consistent with guilt, consistent with innocence. You should find the defendant not guilty. You're not searching for doubt. You're ultimately searching for the truth. So even if it's a heavy burden, it doesn't mean the decision is difficult in cases. You are instructed not to search for doubt. You're to search for the truth. And there's not a reasonable hypothesis in this case consistent with the defendant's innocence. There just isn't, right? There's one truth in this case. There's one side of the story, and it happens to be the defendant's story as well, but it's consistent with everyone else's story. It's because that story is the truth of what the defendant did to her friend Shad. And based on that, we would ask that you return guilty verdicts on all 3 counts. Thank you.
Mr. Ehrlich, are you ready to make a closing argument?
Yes, I am, Your Honor. Thank you. Your Honor, may it please the court, ladies and gentlemen of the jury, Mr. Lassay, Mr. Saunders. Well, as the attorney for the defendant, Taylor Denise Schabusiness, I'd like to share with you that I believe this case is a puzzling, unclear, confusing, and bizarre set of facts. It is unknown what really happened between February 22nd of 2022 and February 23rd of 2022. What we do know in this case is that numerous law enforcement officers testified. We had detectives, we had police officers, we had Dr. Trankita, and DNA experts forensic specialists, lots of different people, some citizen witnesses. I'd ask that you consider setting aside your emotions and decide this case based on the facts that have been presented. You've sat here for the last 3 days. You've been here in court. I know that you've listened very closely, but don't assume anything. When you deliberate about all of the facts. What we do know is that law enforcement officers on February 23rd of 2022 went to 829 Stony Brook Lane in Green Bay, this small Cape Cod home, and made contact with the occupants, Tara Pakinich, Stephen Hendricks, and Ava Wheelock was woken up, but they were all sitting at the kitchen table, and officers came in to see what was going on. There was a concern, obviously, that there was a bucket down at the end of the stairs. And we heard from Detective Roth that this was an ongoing investigation, law enforcement. They were trying to piece this together. It's an unusual situation. So they were trying to find out what happened. Unfortunately, I believe it was Officer Plonky and Officer Wanish, they testified, they came here and indicated that they went down to check out what was in the basement, and there was the head of Shad Thyrion in that black Fleet Farm bucket. And the investigation continued on. But what I submit to you, ladies and gentlemen, is that there really are no eyewitnesses as to what really happened down in the basement. There was no Taylor Schabusiness there, no other people there. And so that'll be something that you'll have to consider and think about. Then law enforcement realized that there was a secondary scene, and that was at 2353 Eastman Avenue, apartment 1 of that parking lot. And you saw the video. The officers, I think it was Officer Garth Russell, and a couple of other ones, they were walked out. Microphone. Sorry. Thank you. The officers walked up and they parked a distance away, and they walked up in the snow and they saw a line of cars in front of the apartment complex. And they saw that a minivan. It was a gold Town and Country Chrysler minivan, and that was a vehicle of concern. Had some snow on the back windshield. There were vehicles on either side. And the officers walked up and they saw some lights on the van. And then they saw someone come out the front door, and it was my client. It was Taylor Schabusiness. At that point, she was arrested by Officer Russell, and another officer then realized there was a male inside of the apartment number 1 down the hall. Ended up being Scott Tomes, and he was told to lay on the ground and held at gunpoint, and then he was arrested. So 2 people were taken from the apartment building and taken down to the police station. There was a search of the Eastman Avenue apartment. We don't have any body parts there. I would submit that there really wasn't anything of evidentiary value there. And that was that. Later on, officers and detectives realized that minivan was something that they were concerned about, so that was taken down to the police storage garage. And then we found out that from Dr. Tranquita and some of the other forensic specialists, Andre, I believe it was investigator Andre, and Zarnecki. And so they donned Tyvek gear, protective PPE equipment, and they methodically investigated the back of the minivan, and they found the crock pot box that was in a laundry basket sitting on a seat, and there were human remains in there. Nobody saw Taylor Schabusiness driving this minivan. So these are some of the facts that you got to think about. Don't rush to judgment, but talk about it, analyze it. as jurors, you have to analyze the facts that you hear and you have to apply the law that the judge gives you. It's a daunting task. So then we hear, you saw the video, the interview between Detective Groff and my client, Taylor Schabusiness. She was taken down to the Green Bay Police Department. Photographs were taken of her, and clothes were taken, and she was put in a yellow suit and then later a blue suit, but she was asked questions. And you got to remember what she said and what questions were being asked. She did say during the interview, I can't think right now. I'm effing nuts. She said that she was up all night, that the body would rebuild itself. She said weird, odd things. Consider her credibility. Consider what she says. Consider what she said to Detective Groff or Detective Scanlon. She said stuff, I would submit that she said things that didn't make sense. She says, I have no idea to some of the questions that the detectives asked her. You remember seeing the video on the screen. I'd ask that you recall that she had inappropriate laughs, inappropriate smiling, odd responses. I would submit that she indicated that she did not have sex. She did not have penis to vagina intercourse with Shad Thyrion. She indicated that she came to the residence and they went downstairs and within 5 minutes they got to it, whatever that means. She talked about during the interview with Detective Groff rebuilding muscle or rebuilding into muscle. Sometimes she wasn't responsive. She talked about hearing gunshots, but I believe Detective Groff said that there were no gunshots in the area of Stony Brook, Eastman Avenue, some other place. She said she was paranoid. She said weird things like, I don't like open spaces. I don't like open spaces. No clothes came off. No kissing. She said that she allegedly put the dildo into Mr. Thyrion's backside, his butt area, his anal area. There's no DNA. We heard from Kevin Scott, DNA expert. He must have done real well in school, in chemistry and all that. But the swab from the dildo, item J1, it says the possible contribution of DNA from Shad Thyrion is inconclusive due to the complexity of the mixture. I would argue that his DNA is not on the dildo. So I would argue that even though the state is charging out third-degree sexual assault, there is no shred of evidence to support that particular charge. And I'd ask that you take that into account. No evidence at the Eastman Avenue apartment. When Detective Groff had my client come down to the Green Bay Police Department with Detective Kevin Kempf, they were talking with her for a while. The interview was maybe 3 hours or so. And then they took a break because Ms. Schabusiness had cuts on her thumb, scratches on her palms, other cuts on her fingers. Some of them were deep. You saw the pictures because I believe they were published. And she was taken over to St. Vincent's Hospital for medical evaluation. I would submit that the blood on her hands may have been her own because of the the deep cuts that she had suffered or that she had. The defense had subpoenaed Mr. Scott Tomes. He was unavailable, and he gave an account of that night. And he had indicated, at least on Monday night, that would have been February 21st, that Taylor Schabusiness and her friend Shad came over. He had seen Shad before, but didn't know his name. And then he thought that they hooked up to do meth. And then he talked about his vehicle. And he talked about that Taylor Schabusiness had used his vehicle in the past and didn't get permission on that particular night. Then he indicated that he was drinking. And then he indicated that Taylor Schabusiness returned to his house around midnight with his vehicle, went to her bedroom, and he had a suspicion that she may have been high on drugs. And then he had indicated that Taylor had the bedroom and that he would sleep in his chair. So that's, something else that you have to think about. We heard from Lieutenant Buckman. He was a veteran on the Green Bay Police Department, and that he was doing some investigating, and he wasn't sure if Taylor Schabusiness was a suspect or a victim because it was an ongoing new investigation. So that's something you have to take into account as well. The state brought up some photographs, a picture of Taylor with her phone. And young girls, I submit, they like their phones. So do all kids, young people. They like their phones, and they look up things on the internet for a variety of different reasons: shock value, curiosity. But we have a situation here where Taylor did do some searches about Jeffrey Dahmer. I would submit that that's a ruse, that doesn't necessarily mean anything, and that people search the internet for all kinds of things on the internet, and that it's for shock value. So that shouldn't really play any part in this case. I would ask that you discount that and set that aside. Now, I would argue that I would argue that it's not a clear case here. Was this an accidental death? Did Taylor Schabusiness kill Shad Thyrion? Was there intent to kill Shad Thyrion? Did Taylor Schabusiness have the mental purpose to kill Shad Thyrion? Different theories, different things for you to think about. You are all like analysts, and you have to assess and decipher the facts. The facts here are very complicated, confusing, unclear. 2 different locations, no eyewitnesses. Taylor Schabusiness, we learned that she went to school with Shad Thyrion, middle school, Bayport High School. They were friends. They hung out. You heard from AJ Gannon. He hung out with them as well. Can you trust what someone says when they're hopped up on meth, on drugs? The state wants you to look into Taylor Schabusiness's mind to find out what her intent was. And that's a difficult task. Did she have a clear mind on February 22nd of 2022 as to what was really going on? Accidents can happen. When accidents happen, people can make other choices in a panic. Something for you to think about. This sexual assault charge, how can you have sexual intercourse with the facts that have been laid out and presented to you? It's mind-boggling. How can you have sex when genitals are in one place and body's in a different place? It's foggy, it's cloudy. It's hard to imagine, almost impossible to try and figure out what did or didn't happen. I would submit to you that no sexual assault occurred. I'd ask that you find her not guilty of third-degree sexual assault. You can't rely on everything Taylor Schabusiness says. Think about that, please. She chose not to testify under our Constitution of the United States of America. She doesn't have to testify. That's what the law provides. You don't have to take the witness stand. You have a right to remain silent, and you can't use that fact alone against her. I would argue that based on all of the evidence and the testimony in this case, that you find my client not guilty of all the charges. Thank you very much for your time.
This case is puzzling. This case is bizarre. This case is in absolutely no way unclear. It is crystal clear what happened to Shad Thyrion, and we know that. We know that because the defendant told you. She told you what she did to Shad Thyrion. Is it bizarre? Is it unnatural? Is it strange? Yes, absolutely. People do bizarre, unnatural, strange things. They engage in criminal conduct. People kill other people and they dismember them. That's what Taylor Schabusiness did. And we know exactly what she did because the words from her mouth told you with specificity what she did. Can we trust always what Taylor Schabusiness says? No, but as Mr. Saunders told you, we trust but we verify. We didn't stop at taking her statement. We corroborated. She guided the investigation with the specificity of her statement. How can we not trust her statement when she describes in detail the mechanism of injury, which is exactly what is described and confirmed by Dr. Tranquita? Excessive strangulation over a period of time with layers of injury, exactly as she described it. Described that his tongue would be out. She described that. Dr. Tranquita described that and showed you that. She described his struggle. He's struggling for his life and she continues to pull that chain, demonstrating her intent to kill Shad Thyrion. And we know that because we see that in the physical evidence. We see the marks on Shad's tongue. We see the damage to his neck. She described to you what she did with his body after she killed Shad. And we know that it's true because the body parts were exactly where she told you they were. Detectives are finding everything she says on scene, and you saw it with your own eyes, that just what she told you is exactly where those things were located in that residence. She wasn't cloudy. She wasn't unclear. She wasn't hopped up on drugs. She knew where to find the drugs. She knew where they'd find the pipe. She knew where they'd find the chains. She knew where they'd find the knives. She knew the name of the bag where the body parts were going to be located. She could tell you that she put the organs in plastic bags. She could tell you that she cleaned up with Clorox wipes and she put them in the bags as well. She could tell you that his lower extremities were in the car. This is the most specific confession anyone could ask for, and it is corroborated in detail by the work of the Green Bay Police Department. This is bizarre. This is strange. This is unnatural, but it is in no way unclear. We know exactly what happened. We know exactly what Taylor intended to happen for all three of these offenses. She engaged in intentional conduct in each of these acts. You are asked to look at each of the 6 elements, and there are only the 6 elements that Attorney Saunders described to you. That as to count 1, she did cause Shad's death. There is no doubt she had the mental purpose to do that. and that she knew that her conduct was practically certain to cause it. She described to you how she visualized him struggling, blood coming out of his mouth, but she did not stop. He's turning purple, but she did not stop. He's coughing up blood. He's pissing himself, in her words, but she did not stop. This was a deliberate choice on her part to kill Shad Thyrion, and she knew that her actions were going to cause that. And in fact, she was asked whether or not she liked it, and she confirmed that she liked it. She was asked whether she was sexually aroused by killing him, and she said she was. Her mental purpose was clear. As to the mutilating the corpse, again, there's no doubt that she intentionally did that. She described the detail. She described her frustration as she's mutilating this corpse, and she described her purpose in doing so. How else am I going to get the body out of the house? How else am I going to get away with this if I don't cut this body up? And she didn't just cut it up and leave it there. She cut it up, she packaged it, she cleaned up after herself. Her purpose in dismembering Shad was clear. She wanted to attempt to get away with this crime. A crime that she intentionally committed, a crime that was not accidental, that was not a surprise to her, that she didn't wake up from this nightmare and then call the police and call Shad's mom. No, she made the second deliberate choice. After deliberately choosing to kill him, she deliberately chooses to dismember him and attempt to cover up her crimes. And likewise, the sexual assault is equally clear. There's no doubt that she had sexual intercourse, and for counsel to say that we can't merely accept the word of the defendant, you're asked routinely in sexual assault cases, juries are asked routinely to take the word of a crime victim with no physical evidence. We don't have to take the word of the crime victim. We have the word of the defendant who confesses to this crime and tells you exactly what she did, again, with specificity, and tells you, you know what, I did this and I did it with that dildo. And here's where you can find the dildo. It's in the wall, it's in the box, I put it away. And what happened? They found it in the box, put away exactly where she described that it would be. And she clearly was sexually aroused by this whole incident, and she described that to you herself. So clearly it follows, it makes sense, it's logical, it is reasonable that she did exactly what she told you she did. There is absolutely no reasonable hypothesis consistent with her innocence. The only hypothesis, the only choice that you have before you here today is to find Taylor Schabusiness guilty of each and every count for which she is charged. All of those elements have been proven beyond a reasonable doubt, and I ask that you return a verdict of guilty. Thank you.
Now, members of the jury, the duties of counsel in the court have been performed. The case has been argued by counsel. The court has instructed you regarding the rules of law which should govern you in your deliberations. The time has now come when the great burden of reaching a just, fair, and conscientious decision of this case is to be thrown wholly upon you, the jurors, selected for this important duty. You will not be swayed by sympathy, prejudice, or passion. You will be very careful and deliberate in weighing the evidence. I charge you to keep your duties steadfastly in mind and, as upright citizens, to render a just and true verdict. You are to decide only whether the defendant is guilty or not guilty of the offenses charged. Any consequences of your verdict are matters for the court alone to decide and must not affect your deliberations. The following 6 forms of verdict will be submitted to you concerning the charges against the defendant, Taylor Schabusiness. 1 reading, we the jury find the defendant, Taylor Schabusiness, guilty of first-degree intentional homicide as charged in count 1 of the information. Another reading, we the jury find the defendant, Taylor Schabusiness, not guilty of first-degree intentional homicide as charged in count 1 of the information. Another reading, we the jury find the defendant, Taylor Schabusiness, guilty of mutilating a corpse as charged in count 2 of the information. Another reading, we the jury find the defendant, Taylor Schabusiness, not guilty of mutilating a corpse as charged in count 2 of the information. Another reading, we the jury find the defendant, Taylor Schabusiness, guilty of third-degree sexual assault as charged in count 3 of the information. Another reading, we the jury find the defendant, Taylor Schabusiness, not guilty of third-degree sexual assault as charged in count 3 of the information. It is for you to determine whether the defendant is guilty or not guilty of each of the offenses charged. You must make a finding as to each count of the information. Each count charges a separate crime, and you must consider each one separately. Your verdict for the crime charged in one count must not affect your verdict on any other count. This is a criminal, not a civil case. Therefore, before the jury may return a verdict which may legally be received, the verdict must be reached unanimously. In a criminal case, all 12 jurors must agree in order to arrive at a verdict. When you retire to the jury room, select one of your members to preside over your deliberations. The presiding juror's vote is entitled to no greater weight than the vote of any other juror. If you need to communicate with the court while you are deliberating, send a note through the bailiff signed by the presiding juror. To have a complete record of this trial, it is important that you communicate with the court only by a written note. If you have a question, the court will talk with the attorneys before answering it, so it may take some time. You should continue your deliberations while you wait for an answer. The court will answer any questions in writing or orally here in open court. When you have agreed upon your verdict, have it signed and dated by the person you have selected to preside. After you have reached a verdict, the presiding juror will notify the bailiff that a verdict has been reached. Everyone will return to the courtroom. The verdict will be read into the record in open court, and the court may ask each of you if you agree with this verdict. Now, ladies and gentlemen, this is the unfortunate time, because now is the time when we select the alternate jurors. Let me tell you what the process is going to be. The computer has selected 4 of you. We're going to read those names here shortly. If your name is read, I'm going to ask that you simply stand up and go have a seat in that first pew right there, because I'm going to want to address you, first pew right here, because it's open. And I'm going to address you after the other jurors have been excused. The remaining 12 jurors are going to participate in the deliberation process, and you will accompany the bailiffs to the jury room. If you're selected as an alternate, your participation in the case at this point will be concluded. I will make sure, however, that you are addressed by a bailiff who will assist you in retrieving any items that you may have in the jury room. So at this time then, I'm going to ask that the clerk read the names of the 4 jurors that have been selected by the computer randomly.
Nicholas Rosick. Sean.
That you will, to the utmost of your ability, keep all jurors sworn on this trial in some private and convenient place, subject to the direction of the court, until they have agreed on their verdict or are discharged by the court, and that you will not, before they render their verdict, communicate to any person the state of their deliberations or the verdict they have agreed upon, so help you God.
I do.
Thank you.
All rise for the jury. Might be seated. I want to first address Mr. Rosick, Mr. Lynette, Mr. Beerhalls, and Ms. Schrader. I want to thank you very much for your service on this case. You've all paid careful attention. I've been able to observe all of you throughout the trial, and I really appreciate that. So do all the parties. At this time, your service in this case is completed. Many jurors ask if they're allowed to discuss the case with others. at the conclusion of their service. Because your role in this case is over, you are not prohibited from discussing the case with anyone. However, you should know that you do not have to discuss the case with anyone or answer any questions about it from anyone other than from the court. This includes the parties, the lawyers, the media, or anyone else. If you do decide to discuss this case with anyone, I would suggest that you treat any discussion with a degree of solemnity such that whatever you do say, you would be willing to say in the presence of your fellow jurors or under oath here in open court in the presence of the parties. Finally, should any of you have any questions before you leave today, please let the bailiff know before you leave. And you can confer with me at any time before answering any questions asked by anyone if you choose. The bailiff is standing right back there. I'm just going to ask you to get up then and accompany her out that door, and if there's anything that you need to retrieve. But again, thank you for your service. Anything to take up before we recess? Mr. Saunders?
No.
Mr. Freilich?
Not at this time.
Very good. Then we are in recess. I'd ask the parties to remain very close here to the courtroom for at least 30 minutes. Oftentimes, if questions come in, they come in early. After that, if you just simply leave a cell phone number where we can reach you, then you're free to depart. But I'd still ask you to remain close to the courthouse. But at this time, then, we are in recess.
Thank you.
McRaney,
Oh yes.
who killed the Burke's husband.
He actually Gordon had his photo taken with Gerald McRaney, and somebody took of the photo and did a painting of him and turned Gerald McRaney into Jesus. So I thought that was kind of interesting.
That's weird. Yeah, well, someday, Paul, if I'm blessed enough, I'll be in that picture next to Jesus. So we'll see what happens. Well, Lynette, I'll let you go.
Okay, well, thank you very much. And
my pleasure, and thank you for being concerned about your friends and
okay.
enough to where you reach out to make sure they're safe.
Well,
he's got a true friend in you, and he needs. I hope he treasures that. So
I live alone, and I always say, I worry about being cat food because, something happens and nobody notices, what happens when the cat gets hungry.
exactly, and I've been on calls like that where it was, someone calls in an apartment and they didn't even notice the smell. What they noticed was those. I don't even want to say the name to gross you out, but those creatures that come out of dead things.
Yes.
Were coming through their maggots, but they were coming through their vent because they lived below this person. So they're coming through the ceiling vent, and they says, "Will you go up and find out how if her apartment, she's just not cleaning it or what the heck? Because this is ridiculous." And we went up and we smelled, and we knew what we were going to find. And sure enough, she'd been down for probably over a week. But
well, there was a friend of mine in Cornwall in the UK. They're one of the few reptile rescue people in the United Kingdom, and they got called out to a scene where the guy had been dead for a month, and they had all of these reptiles that like snakes that hadn't eaten for the whole time, and they needed somebody who knew how to handle them because the police didn't know what to do.
Yeah, no kidding. That would be. I mean, yeah, we're gone. We don't know it, but that's not a way I want to be found. So
yes.
Unless I'm in the mountains, let me be in the mountains and totally be decomposed and gone, and they can find a bone or something. But,
yeah. Okay.
All right, well, Annette, hey, it's been a pleasure.
Okay.
You sound like a type person I'd enjoy chatting with.
Okay, well, thank you. You have a good day.
You too.
Okay, bye-bye. Okay, that was a really fun chat with the policeman. Oh boy, he was saying that my friend Gordon looks like actor Ed Harris in Apollo 13, and I looked on Google and went, yeah, he does kind of look like him. So interesting. I think Gordon will like that. He said also a hint of Robert Redford. And I went, oh, he won't mind hearing that either. So, okay, well, let's go back to the state trooper who pulled over the car with when he was speeding. I think he said 19 over the speed limit. And while he's talking to the guy, he notices that there are bullet holes in the side of the Camaro. So here we go. Back to Louisiana.
Random guy pulls up behind me, said, "Hey, this guy's looking for that kid. I need to know if this car has been reported missing, stolen." And yeah. Okay. There's 3 bullet holes in the driver's side, right behind the driver's side door jamb, and like 1 in the jamb and 2 right behind it. And I just, this guy's name is Mike. I'll go ahead. I'll give you the. Okay. All right. Okay. Okay. What I got is that gave him permission to have this car. Okay. So I just need to know if it's been reported stolen or missing, so we can work it up from the back. Good deal. Thank you, man. Bye. I get him out. And I know he's BSing to me about where he's going. He says he's going to his sister's house down here. If you could, hey, talk to him. See if you can figure out if the sister thing is legit. He's out of Richwood. I told him, I knew he was lying to me. He said he lived in Winsboro. Put that together real quick. But something else, he said this guy gave him the car. Okay. To give him the car. So I'm trying to, let me see if you can see what this sister thing is. Because he said he's got the GPS on his phone on the back lid. He said that's where he's going. And I knew he was lying then.
Hey, where your sister live at, man? I'm gonna see how I locate her right
Okay.
quick.
All right. Hey, Scooter, do you work with a Ragus? Do you work with a guy named Ragus? Ragus? Yeah. Is there like an investigator named Ragus or something? Okay. Well, the Franklin Parish Sheriff's Office just called, said there's some contact with Monroe PD called Ragus, somebody named Ragus or something, that this car has been given to this boy by another boy who's been reported missing. And something's going on between the two of them. And this boy right here said that other boy gave him permission, but the guy from Monroe hadn't called me yet. So I'm trying to see. He said he was the Franklin Parish Dispatch was going to try to confirm all this and get back with me, but evidently, I mean, he got the 3 bullet holes in it, and the boy's been reported missing. Do we need to do anything specific with the car? Like, do we need to? Crap. Okay, man. I just don't want something bad to come back on this with me letting it go.
I remember hearing that name.
All right. Well, if I need any help, I'll call you back. I'm sorry to bother you, Scooter.
You finna get a call from.
Okay. All right, man. Go ahead. If I need you, I'll holler back. Bye bye.
Hey.
Hey, Chad. Like, this looks close. Like bam, 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 bam. Yeah. And the boy, see, what I'm being told is that the boy who gave him permission to use the car is missing. So he's lying his ass off. We go looking for the person who owns the car, find out that the son of the owner of the car is missing, and now we got bullet holes all in the car.
I got you.
So something's.
Something bad, right?
The only thing he lied about was his address in Winsboro. So he don't have a driver's license, but he lied about living down here. I don't know what he thought that was going to do, but
He lives in Monroe.
lives in Richwood, and the car is registered out of Monroe to the. I don't know who's supposed to be calling me. They said somebody was supposed to call me. The y'all sheriff's office said somebody was calling me.
Yeah.
If he's knows something about this boy that's missing, there's bullet holes. I'd like to at least. We need good. I guess I'll do as much good contact as I can.
You haven't been in the vehicle, huh?
Yes, I just looked in the console, the center console. He had a doobie in the ashtray thing, but I really didn't give it a good look.
Right. Right.
See? I'm gonna do the obvious thing I want to do. Hey. Yep. Put your hands up. Put your hands up. Put your hands up. Put your hand behind your back. Put your hands behind your back. Don't move. Do you understand? Don't move. To get you in the court of law, you have a right to an attorney. Have one present during any questioning. At any time, you choose not to make any statements or answer any questions. You understand? If you cannot afford an attorney, one will be appointed to represent you by the court. Do you understand? Do you understand? Who is that? Who is that?
That's him.
Who is who?
That's Mike.
That's Mike. How did Mike get there? Tell me.
It wasn't me, man. It was.
Okay.
I just hit him, bro. I did.
You just hit him?
I did.
Okay. Lock this down. Lock this down. F-39 to Region 3.
F-39.
Get in there. Get in there.
Region 3, F-39.
And 10-15.
10-4, 10-15, and 16-58. 16-58 is
26 is 125-03057, 125-0357. F-39 Troop F desk.
Good.
Need a supervisor out here. I am LA 17, 1 mile north of LA 4. Can you give me a 21, Sarge? Okay, guys, want to lock it down. Nobody in front, nobody behind. And I've got my sergeant coming.
I cut the car off.
Okay.
Put the key up here.
Okay, that's it. Okay. All right. Hey, Sarge. Yes, sir. Yes, 23 and the 55 on LA 17, just north of LA 4. All right, I get the guy out. He's super nervous. He lies to me about his address. He's got no driver's license. He says he's going to his house in Winsboro. Well, I find out he lives in Richwood. Okay, and I call Monroe. This car has 3 bullet holes in it on the driver's side. I asked the guy, he's been smoking weed, so I asked the guy to search the car. I go around the car inside the passenger compartment, and I can't find anything. It's maybe a little roach in the doobie in the ashtray. We're sitting here asking about it, about the guy that gave him permission to use the car. His mama reported him missing. The driver's name is Michael. I got to get his name here. I popped the trunk. Sarge, there's a dead body in the trunk. Okay, so I'm not. We've blocked in front of the car and behind the car. We've shut the trunk. I have Franklin Parish Sheriff's Office with me. We're at 82. Okay, we're not. We're done. We're go south. Yes, ma'am. Bye.
He looked like he wanted to do something.
Yeah. Okay. Did we hadn't searched him yet?
No, we hadn't searched him.
Okay. Step out of the car, my man. Step out of the car, okay? Look at me. I'm gonna take this off, okay? All right, wait, hold on. Everything's gotta be bagged. Okay. Get out of the car. All right, look at me, Michael. What's your last? Stand here against the car. Do you understand? Don't move.
You get anything on you like what? You keep doing.
Okay, put that sash in here. Anything else on you? Anything on your nuts? Anything in your ass crack? Nothing?
Take a watch.
Okay, give me a watch, bag it. Okay, anything else? No? Okay, you're gonna have some investigators come and talk to you. Do you understand?
Kick those shoes off.
Kick the shoes off. All right, sit up in there. Sit up in there. You're gonna have some investigators come and talk to you. Do you understand?
Yes, sir.
Okay. I'm sorry to get y'all roped into something,
Maybe that's what we're in for.
but I know. I'm sorry. Hold on. Go to that. Sorry, Sheriff. But
Oops. I didn't mean to do that. Let's go back to the countdown, or not countdown clock. It's the count up clock. And I'll look around and see what else is good for killing some time here. I'm thinking that we'll have the verdict in the next hour or less. So,
However, let me see. Let me see what. Yeah, that that hot tub guy. What a creep he is, huh? I'll never forget that interview. One of the weirdest little creepy interviews I've ever seen. But yeah, get them to. Jury watch on the Wisconsin case, head in the bucket. What? Which one's that? I don't know. I don't know which one that is. Head in the bucket. It's crazy looking. Hold on. There's a. Is there a verdict coming out of that already? Has that been sent to deliberation already? Really? I didn't know that. What was that, a 2-day trial? Didn't that just start Monday? My God. It takes longer to cook chili in the crock pot. All right. Gotcha. Never mind. I'm sure she is. I'm sure she's guilty. That's like that's super fast. A 3-day trial. But yeah, I had no clue. I had no clue that it had been that far already. I mean, I paid attention a little bit, but I didn't really watch the case that much. Isn't she just claiming insanity? Isn't that her case? Like, it's just insanity? Yeah, so she must be. Are you going to cover the? Yeah, I don't know. I mean, I've watched a little bit about it. I haven't talked about it very much. I don't know too much. She was denied. So, yeah, I don't know. I don't know. I have heard a little bit about what's going on in that case. What was that? What was that lady's name again? What was her name? I don't remember her name. Oh, is this really live? What's going on here? Anyway, and tomorrow I will when police chief releases a statement, we'll cover it here. Verdict is in, or there is a question. What is she doing? Is she crying? She's been laughing? Wow, really? How come I can't hear? Is there just no sound? 42 minutes. What does that mean? So what? They're gonna she laughed the entire time. I don't think she's pretending to be crazy because I think that anybody that does anything, how come I can't hear? Is there a reason? Is there nothing to hear? What do we got? Oh, so I'm not the only one that's muted? Okay, good. Yeah, I mean, I might as well hang around for why they did this. I didn't even know. I had no idea. And by the way, being crazy is not a defense, in my opinion. I mean, obviously she's crazy if she's doing what this jury has alleged. I mean, that makes anybody crazy. And didn't you say that she confessed as well? I don't know what the 42 minutes means. What does that mean? She scares me. Like, that's a scary. Yeah, I remember when she attacked her attorney. I remember that. Not good. Certainly not good. Well, I keep seeing that 42-minute thing. The jury was out 42 minutes. Wow. 42 minutes. That's it. That's all it took. Jeez. Love a Scorpio. It sounds like there is a verdict, but and I guess they're just waiting for the judge. Oh, here he comes. Judge is here.
My understanding is the jury has a verdict. Is that correct? Yes. Anything to bring up before we bring the jury in, Mr. Saunders?
No.
Mr. Fraley?
No.
Very good. Then we'll bring the jury. My understanding is the jury has a verdict. Is that correct? Yes. Anything to bring up before we bring the jury in, Mr. Saunders?
No.
Mr. Fraley?
No.
Very good. Then we'll bring the jury. Okay, be seated. Ma'am, were you the foreperson? Yes. And my understanding is that the jury has reached a verdict. Is that correct? Yes. Right. If you would hand that to the bailiff then, please. Okay. First verdict reads as follows. We, the jury, find the defendant, Taylor Denise Schabusiness, guilty of first-degree intentional homicide as charged in count 1 of the information, dated this date, July 26, 2023, signed by the foreperson. Second verdict reads as follows. We, the jury, find the defendant, Taylor Denise Schabusiness, guilty of mutilating a corpse as charged in count 2 of the information, dated this date, July 26, 2023, signed by the foreperson. The next verdict reads, we, the jury, find the defendant, Taylor Denise Schabusiness, guilty of third-degree sexual assault as charged in count 3 of the information, dated this date, 26th day of July, 2023, signed by the foreperson. The verdicts appear to be in order. Do either of the parties request that I poll the jury? Mr. Saunders?
No.
Mr. Freilich?
Yes.
Okay. Ladies and gentlemen, I'm going to do what's called polling the jury. It's a very simple process. All I'm going to do is go down the line and ask each of you if this is your verdict. Your answer is either yes or no. I'm going to start in the back corner, ma'am. Are these your verdicts?
Yes.
Ma'am, 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 are these your verdicts?
Yes.
Sir, are these your verdicts?
Yes.
Ma'am, are these your verdicts?
Yes.
In the front to the right, ma'am, are these your verdicts?
Yes.
Sir, are these your verdicts?
Yes.
Sir, are these your verdicts?
Yes.
Sir, are these your verdicts?
Yes.
Ma'am, are these your verdicts? Okay, the jury has now been polled. Ladies and gentlemen of the jury, for today, your tasks are concluded. We're going to start tomorrow morning on the second phase, at which point in the beginning I will give you some further instructions, and then we will get underway on that phase. The attorneys and I have a few things that we're going to need to take up before that phase starts, so I'm going to ask that you be in the jury room by 9:15. I want to start right at 9:15, and we will hopefully get our matters resolved ahead of that time. But for today, your service is concluded. I am going to, again, read you that instruction that I've done every day since you've started. Please do not communicate with anyone about this trial or your experience as a juror while you are serving on this jury. Do not use a computer, cell phone, or other electronic device with communication capabilities to share any information about this case. For example, do not communicate by blog, email, text message, Twitter, or in any other way on or off the computer. Do not permit anyone to communicate with you, and if anyone does so despite your telling them not to, you should report that to me. I appreciate that it is tempting when you go home in the evening to discuss this case with another member of your household, but you may not do so. This case must be decided by you, the jurors, based upon the evidence presented in the courtroom. People not serving on this jury have not heard the evidence, and it is improper for them to influence your deliberations and decision in this case. After this trial is completed, you are free to communicate with anyone in any manner. We are done for today. Have a good evening. We will see you tomorrow morning at 8:50 or 9:15 sharp. I'll rise for the jury. Be seated. Is the matter regarding Dr. O'Donnell still a contested issue? I'm seeing nods from the state.
As of last night, yes.
Okay. So here's how we're going to handle this. I've indicated to the jury that I want them to report at 9:15. Mr. Freilich, it's entirely up to you if you want to bring Dr. O'Donnell here tomorrow morning at 8:15 for me to hear from. But I'm going to indicate to you the parameters of where that situation is. I've reviewed your memorandum, which is all I can really work with because this is what you've essentially said to me. This is what he's going to testify about. The first opinion is that Ms. Schabusiness was acutely intoxicated and impaired by acute methamphetamine use at the time of the alleged asphyxiation. The problem I'm having with that assertion is I'm not sure it's relevant given the status of the intoxication defense. So I'm not sure that having it here is going to assist you in that, but and I need you to understand where I am regarding that topic before you decide that's what you want to bring it here for. The next point is that the long-term and excessive use of methamphetamine has chronic brain damage consequences. The problem with that situation is I don't know that he is competent to diagnose chronic brain damage. So while he could assert that long-term excessive use of methamphetamine has chronic brain damage consequences, I don't think he's going to be qualified to testify that as a professional, I can say to a reasonable degree of certainty used in my profession that Ms. Schabusiness has chronic brain damage. Frankly, I think the only opinion that's been asserted regarding her mental health condition as far as a diagnosis is bipolar, and that was done at Nicolay. And there's some dispute about whether that was an accurate diagnosis, but I don't know that one would qualify bipolar as being chronic brain damage. So I'm concerned that if he's going to come in and start opining about that the connection won't be made. And then, of course, even if he is able to say that she does have chronic brain damage, the next step he has to take is that somehow that impacted responsibility. And I think there's a concern there as well. But I'm putting you on notice of that view that I'm starting to develop regarding the submissions you've made to me. The second bullet point is that long-term adolescent use of marijuana arrests brain development. Again, I'm not familiar with the diagnosis that any qualified psychologist or other professional qualified to make such a diagnosis has actually made in this case. I don't know that one equates brain development with bipolar. I've never heard that, but I'm not an expert. So the notion that you can opine that someone who uses marijuana as an adolescent might have brain damage, I'm not sure is going to be useful to this jury because we don't know if your client has that. And the next step is, how does that affect responsibility? And I'm not sure he's qualified to give that opinion either. The next bullet point is, Ms. Schabusiness was not treated with psychotropic drugs to control or mitigate her psychiatric illnesses. He certainly, and again, I want to say, I'm satisfied that he's qualified as a pharmacologist. I'm not questioning his qualifications as that. Certainly, I reviewed his CV and listened to his testimony at the prior hearing, and he's a qualified pharmacologist for sure. But as far as psychiatric illnesses, again, the only thing that I've heard about from the testimony in the records is a bipolar diagnosis at Nicolay, which these other psychologists have repeated. So that the only thing that one could conclude from this assertion is that she was not treated with psychotropic drugs to control or mitigate her bipolar disorder. And then the question is, how does that impact responsibility? Many people have bipolar, so the next question you have is does someone who has bipolar, will the consequences be that you're unable to appreciate the responsibility in a criminal case? That's another concern I have with whether he's going to be qualified to even testify about that. The next point is psychotropic drugs do have efficacy in a large percentage of patients who take them. Well, I'm satisfied he'd be competent to testify about that. I'm not sure how that actually, first of all, how that relates to whether or not, what she has been diagnosed with, how that would affect an individual by taking psychotropic drugs, and can he say how it would have affected somebody to a reasonable degree of certainty used in his profession regarding the impact of untreated bipolar disorder? That certainly might be within the ken of your other expert, and I do want to indicate you have another expert who might be qualified to testify about some of these things, but I'm very skeptical that this witness is qualified to do so. And then the final point is that Ms. Schabusiness' use of methamphetamine worsened her untreated psychiatric condition. So really, the issue is the impact of methamphetamine on untreated bipolar and the impact of methamphetamine untreated bipolar on someone's responsibility to commit a crime. And I'm just concerned there as well that there's an inability to connect all of those dots with this expert. And so while I'm willing to hear from your expert, because you've asked that, and I think the state is of the mind, we don't even need a hearing on, a Dauber hearing on this, but I'm affording the defense an opportunity at 8:15 tomorrow morning. If you want to bring Dr. O'Donnell in to opine on some of this, but you need to understand that's the concern I have. It'll be a rather short Dauber hearing for this reason. This proceeding tomorrow is in the nature of a civil proceeding. And I'm pretty certain the judge is not even mandated to hear testimony at a Dauber hearing. I can do a paper review and make a determination. And so I can tell you that I've done that paper review so far, and those are the concerns that I have. And I'll want to drive directly at those issues tomorrow. I'm not going to want to hear about a lot of things that if I can testify, I might be able to say a whole lot of things. I'm going to want to know specifically about my concerns, and if they can't be directly addressed, then I would be satisfied that he's not competent to give those opinions. Even though, again, I want to indicate out of respect for Dr. O'Donnell, I'm satisfied that he's a very capable and competent pharmacologist, but I'm concerned about some of these opinions, particularly when the psychologists who would be rendering the diagnoses that he is referring to aren't even in agreement on it. Nonetheless, that's where we're at. Let me just turn to the state. Mr. Saunders, questions on what I've indicated?
No, I don't.
Mr. Frail, questions on what I've indicated?
No, Your Honor, it's very clear.
All right, very good. We'll see everyone then tomorrow morning at 8:15.
All right,
Thank you.
stand up. It's okay. Chance when you're ready. Chris, you good?
Okay, and there we have it. So, yes, same time tomorrow morning for determining what her penalty is. So that'll be interesting. I guess that's when we get all the doctors. They're trying to argue brain damage, but they don't have anything to document that she has any brain damage. Now, as a person with documented brain damage, excuse me, yeah, you can have brain damage, but that doesn't mean that you are a mental vegetable. I'm sorry, honey, I'm not buying it. I don't think that you committed the crime because of your drug use pickling your brain. So, okay, well, that was certainly unexpected. I was thinking it would be Friday. I forgot about, I guess I didn't realize that they had a separate penalty phase. So we'll do this again in the morning, and that ought to be interesting. We don't have to pretend like she's innocent now. I think I'll probably get another nap here soon. And I'll bid you a good evening, and you have a good night over there, Indiana. And we'll see you tomorrow. So guilty, which was pretty much a foregone conclusion. Okay, Bye-bye.